Morning. Sorry, I was 5 minutes late. I was just editing something which has been typed out before I forget. And I know when I was coming, I had it in my mind, so I quickly finished it. Yes.
Item 6.
Yes, Mr. Gogoi, you're an amicus.
Yes. Though I am been reflected as amicus, no copy is served on me till now.
Is it?
Yes, my lord.
Okay.
So we'll
We'll give it today and next week.
Yes, any fixed day.
Mr. D. Gogoi, and an amicus curiae draws the attention of this court that the copy of the paper book, but there may not be a paper book here, copies of the appeal memo, copies of the appeal memo and the relevant papers has not yet been provided to him by the registry of this court. Let the same be made available to the amicus learned amicus curiae, relist on such and such date. Yes, next.
Next Tuesday.
मैं free जो लॉसेस but I
Oh,
didn't mention I think not 13 losses difficulties losses so matter maybe kindly pass for the day losses on next week losses
Only 3 adjournments would be given at the mentioning, and the rest we will see when the matter is called. In terms of seniority, you may make your mention and then wait for your turn. By seeing the number of advocates waiting, it might be, I think I only have 15 or 17 matters.
Yes.
All matters, if gets adjourned, then what will happen?
that's it
So only those cases where very important, you make a mention, and else we will see when the matters are being called. Yes, Mr. Ganguly.
Yes, with regard to item number 14, Lordship,
Hmm.
it's a hearing matter, Lordship, a criminal revision arising out of conviction. Matter has been settled between the parties, Lordship. This is the instruction which I have got, but the modalities have not been informed, Lordship. So I pray that
Ms.
matter may
Bohra,
come
you
up
were there?
next week, Lordship.
Okay. In item 14, Mr. Ganguly, learned counsel appearing for
The petitioner.
petitioner. Your name's not here.
No, I am on behalf of Mr. SKJ. He has some personal difficulty.
Learned counsel appearing for the petitioner submits that there is some out of court settlement being worked out in the matter. However,
Settled between the parties,
uh, uh,
things are yet to be-
okay, he submits that the matter has been already settled out of court. However, the modalities are yet to be worked out and accordingly seeks a short accommodation. Prayer is not opposed. Relist, yes. When do you want it? On such and such date. Yes, next.
item 10 losses hello item 10 losses with this case my
Item?
colleague my item 10 hearing matter losses
Hmm.
my colleague my Mr. MR Chaudhary losses he
Hmm.
my lord is undergoing a minor surgery losses
Hmm.
file is
And you are for whom?
my lord a petitioner losses
File is not with
file
you.
is with me him losses so today is my lord I'm problem without my lord brief losses he is also in hospital
Mr.
MH Ahmed
Mr.
MH Ahmed
M.H. Ahmed, learned counsel appearing for the petitioner. You are M.H. Ahmed,
losses
but you are the first counsel in the petition.
but he is my lord
So what? You are there.
my lord yes I'm there but he is
You just have to point
my lord,
out what
he
is the
is
illegality
losses.
committed by the court.
Well, he was supposed to come, but he is in hospital.
But you have come.
My lord, but brief is with him. He engaged me, but he
Submits
take-
that the outgoing counsel, Mr. M.R. Chaudhary,
yes, lost.
is indisposed and accordingly seeks a short accommodation.
Lost.
Since the matter pertains to the year 2015, however, considering the medical emergency, the matter is reposted on such and such date. Yes.
Obliged.
Yes, Mr. Lordship. Item number 7, Lordship, it is appeal against acquittal, Lordship. Respondent number 2 died in the year 2024, Lordship. Death certificate I have submitted.
Huh?
Death certificate is there.
So you want to
I'm for
amend?
the respondent number 2, Lordship.
Huh?
It's an appeal against secretary. I am for the appellant. She's for the respondent. So respondent has died, so matter may be closed. There is nothing left.
Oh, you are for the
She is the accused.
accused has died. Oh, appeal against acquittal.
Lordship.
Oh, 7 to death. Heard Mr. D. Talukdar, learned counsel appearing for the appellant. Also heard M.S.R. Boro Bora. I didn't know it is Boro Bora. So I keep confusing sometime. I call you Boro, sometime Bora. So anyway, the confusion is clear now. M.S.R. Boro Bora, learned counsel appearing for the accused respondent. Mr. MP Goswami, 2, huh? MP Goswami, APP. MS so-and-so submits that during the pendency of the appeal, the accused has expired, and in support of her submission, she produces a death certificate issued by the Government of Assam, Department of Health and Family Welfare, Jorhat Medical College and Hospital. Stop. A perusal of the said death certificate indicates that the accused expired on 30/3/2024. Stop. That being, in view of the aforesaid endorsement and the death certificate so and so, nothing survives for adjudication in the criminal appeal. Accordingly, it's abated or it'll be closed.
It will close.
Accordingly, the appeal stands closed.
Much.
May I please, your lordship? Lordship, I beg to mention item number 8, lordship. This is an appeal against conviction. It involves POCSO Act, lordship. So the respondent has to be represented. Though the respondent number 2 was served, but none has represented. As per the notification recent, amicus has to be appointment as nobody has.
File.
Item
File.
number 8.
Fine.
As per the office note dated 7/2/19 and the order also reflects 22/2/19. The respondent number 2 is the informant. The notice has been served, but none has appeared on their behalf. Order dated 22/2/2019. This is the notification. The amicus needs to be approved.
So R2 has been received.
It has been received, but Roman 3, lordship, next page.
So amicus or legal aid counsel?
But he has to be represented.
Heard Mr. Chaudhary, na?
Lordship,
You are
only
Mr.
V.A. Chaudhary.
B.A. V. Victory. Your name is
Vikram. lordship.
Vikram, correct.
Mandit.
Mr. V. Chaudhary, V.A.
A, lordship.
V.A. Chaudhary, learned counsel appearing for the appellant. Also heard Mr. MP Goswami, learned APP for the state respondent. Mr. Chaudhary draws the attention of the court to the office note dated 7/2/2019 which indicates that service in respect of the informant stroke respondent number 2 has been complete.
Lordship.
However, there is no representation till date
Lordship.
on behalf of the informant respondent number 2. In view of no representation on behalf of the informant, who is the informant?
Lordship, the father.
It is further observed that the informant stroke respondent number 2 is none else but the father of the victim girl. That being so, considering that there is no representation till date, despite receipt of notice, this court appoints Kostov Malin Mohanto as learned amicus curiae to represent the informant in the criminal appeal. Let registry furnish copies of the appeal memo to the learned amicus curiae. Relist
So any day next week or next to next.
after 2 weeks so that they did because let registry reflect the name of the amicus curiae in the cause list.
Deeply obliged.
Please, your lordship.
With the consent of others, I beg to mention item number 9. We need some more time to prepare the case.
What is to be prepared? You wait. In the meantime, you see the file.
Oblige.
Don't worry.
May I please, your lordship?
These are opportunities. Let us see.
May I please, your lordship? Lordship, in item number 3, the arguing counsel, Mr. P.J. Soikia is, lordship, unwell.
You are there. The revision petition.
Lordship, but the arguing counsel is Mr. P.J.
That's
Soikia.
all right.
Lordship, the some time may be given, Lordship.
Today I'm giving you, next time I will not give you. You look into the file, the old matters. You should be waiting to get such opportunities. And when you get it, you must grab it. You just have to present your case, isn't it? You are a counsel also. So next time you read the brief and come. What is your name?
SP Das, Lordship.
SP?
Das.
I've heard MS SP Das, learned counsel appearing for the petitioner. Ms. So-and-so submits that since the arguing counsel, Mr. PJ Saikya, is unwell,
Lordship.
is indisposed, the matter may be taken up for hearing on any other date. Prayer is not opposed by Mr. MP Goswami, learned APP for the state. Repost on such and such date.
Of Lordship.
For admission, item number 1.
Kali matter to kuntu.
The hearing of the certainly.
That Gogoi's matter.
No matter, it is
I think there is just 2 admission. After that, Gogoi's matter. Huh?
it should be hearing matter, my lord.
Who's yours?
Yes.
Then you wait. Let me take that matter which I was already heard. If you want your matter to be heard today.
Then, my lord, let it be.
Why? What is this? This is
There are no cases made out.
306.
Yes, my lord. And actually, this lady fled away from her first husband. We are living happily. But ultimately, she has committed some theft, my lord. She was taken into.
Mr. Goswami, you are there.
I am there, man, but say admission matter, I had not.
You're
taken
not
the record,
prepared.
Not records, I have to see.
No, but what about this respondent number 2? Who's 2?
to do with the informant, my lord.
Where is the informant?
Informant, actually, the party is not to be required, even though we have done it, my Bolin
No,
Kalita.
but what happened to the notice?
Notice has been sent to them. They have not responded.
Has it been received? Is
It
there a
sent by registered post, my lord.
is there a judicial order
That I have
recording the?
not noticed, my lord.
It says registry to appoint an amicus curiae for respondent number 2.
And that was the court's opinion last occasion.
Yes, then we have to appoint
Yes.
Mr. Biswas.
Yes.
That's a judicial order.
Yes, sure, my lord.
Mr. Gogoi, how much practice you have? Very well. Come, would you like to assist this court for the respondent number 2? Come this side. Heard Mr. S.C. Biswas, learned counsel for the petitioner. Stop. Also heard Mr. M.P. Goswami, learned APP for the state respondent. None has appeared for the respondent 2 on call. It appears that though this court had directed by order dated 1/11/2025 to appoint an amicus curiae. However, till date, the registry has not taken any steps to appoint the amicus curiae. Accordingly, this court appoints Mr. T. Gogoi, learned counsel, who is present in the court at the time of taking up this matter as amicus curiae for the respondent number 2. Let registry reflect the name of so-and-so in the cause list. Let registry also furnish the copy of the appeal memo and other relevant documents to the learned amicus curiae appointed for respondent number 2. Relist on, yes. Records are he, sir?
Yes, Lordship.
Yes.
Then I'm fixing it for hearing.
Lordship.
তার আগত লিখি দিব. It is also brought to the notice of the court that the case records have in the meantime been received. Let the matter as such is ready for hearing. Repost on such and such date for hearing. Mr. Gogoi, have a look properly.
Item number 2.
Matter may be fixed for hearing, my lord.
Who is there for R2?
আর তো মিলত ইয়ে টু বি এপিয়ার মিলত কি ফাইল
No one has come. Yes, we'll appoint someone then.
Legal appeal.
Yes.
Yes.
Heard Mr.
A.M. Ahmed. A.M. Ahmed.
A.
Ahmed.
A.M. Ahmed.
Yes.
Learned counsel appearing for the appellant. Also heard Mr. M.P. Goswami, learned APP for the state respondent. None appears for the respondent number 2 informant. Informant
Yes.
On call, despite service of notice having been completed as per the as per the
Order dated.
as per the last order of this court dated 1/11/2025. Stop. In view of no representation on behalf of respondent number 2 till date, this court is pleased to appoint Mr. R. Dev, na? Full name? Mr. Rajiv Dev, learned counsel who is present in the court as an amicus curiae to represent respondent number 2 in the instant appeal. Let registry furnish copy of the appeal memo along with other necessary documents to the learned amicus curiae so appointed. Let registry further reflect the name of the learned amicus curiae in the cause list. Matter is ready for hearing.
Yes.
It is further noted that the case records in the meantime has been arrived. Matter is ready for hearing, report for hearing on such and such date.
12 December.
For hearing item number 17.
Yes, Mr. Gogoi.
Yes, Lordship. Lordship, if I met any Lordship inconvenience to yourself, I'm apologize
No,
for that.
not at all. You argue on the merit.
Yes, Lordship.
Let us now see everything.
Your Lordship. First of all, my point is, Lordship, that Lordship, the trial court, Lordship, properly not consider my evidence, Your Lordship. Lordship, here in this matter, Your Lordship, charges have framed under section 7 of the LPG, Your Lordship, and which is punishable under section 7 of the EC Act, Your Lordship. Lordship.
Charges have been framed under
7, Your Lordship. Your Lordship.
7 of ESC.
EC Act, Lordship.
ESC.
Yes, Lordship.
Yes.
EC Act, Lordship.
Yeah,
Prior to
in
start, Your
Divine.
Lordship.
Yes. Yeah. Yes.
Lordship, before you start, Your Lordship, here, Your Lordship, when EC Act come, Your Lordship, burden of proof is upon me, Your Lordship. So though last Lordship, burden is upon me, Your Lordship, prosecution have to prove yet initial part, Your Lordship. He have to establish the offense which has been alleged to be committed, Your Lordship. Here in this matter, Your Lordship, the foods search, Your Lordship.
The offense is using of domestic LPG cylinder
Cylinder
for commercial purpose.
Commercial purpose, Your Lordship.
Yes. But Mr. Gogo, you must also be aware that right now I'm exercising a very limited jurisdiction.
Lordship, can
This is not the third, this is the third court. So basically not on factual aspect. You have to point out what is the illegality committed by the, what is the illegality manifest on the record of the appellate court.
Yes, Lordship.
Because you are challenging the appellate court or you're challenging both?
Both, Your Lordship. Both, Your Lordship.
Yes.
Your Lordship, wrongly appreciate that evidence, Your
See,
Lordship.
that is why I'm saying
That
wrong appreciation cannot be a ground here.
Your
Because as far as if there is some evidence to show,
Yes, Lord.
that is sufficient. The sufficiency of the evidence cannot be gone into by this court while exercising revision jurisdiction.
Lordship.
You please understand that
Yeah.
this is not an appellate jurisdiction.
Lordship.
So appellate jurisdiction, of course, will reconsider all the evidence,
Lordship.
reappreciate them,
Lordship.
reanalyze them,
Lordship.
right?
Yes, Lord.
But this court is now only exercising a jurisdictional, a very limited jurisdiction concerning only error of jurisdiction.
Yes,
So
Lord.
you confine your argument to that. What is that error apparent on the record? What is that jurisdictional error? What is that illegality?
Yes, Lordship.
You point that.
Your Lordship, illegality is the Lordship interpretation of burden of proof, Your Lordship.
Yes.
The which is that trial court has presumed that that burden is mine, but without establishing that. fact.
Initial foundation.
Yes, Lordship.
What is that? Let us see the trial court judgment then.
To start from that page number 10, Your Lordship.
Hmm.
May I read, Your Lordship?
Yes, please.
This case is initiated on receipt of the complaint filed by the complainant Sri Nakibur Rahman and Borbora, Inspector of Food and Civil Supply, Consumer Affairs, Jorhat, alleging and therein that on 8/9/2009, while a team of officers of Food and Civil Supply and Consumer Affairs, Jorhat, jointly visited the MS Prakash Hotel, Raja Maidam Road, Jorhat, they found domestic LPG cylinder being used in commercial purpose. On being asked, accused Satyanarayan Sharma could not produce any document in support of his using the said domestic LPG cylinder for commercial purpose. That accused thus violate the provision of 7(1)(c) of the LPG Regulations Supply Distribution Order 2000. Therefore, that complainant seized one empty and another partly used LPG cylinder from that said hotel. On receipt of the aforesaid complaint that the case was registered and summon was issued to the accused person. In due course, the accused person on receipt of a summon appeared before a court, and copies of the relevant documents were furnished to him as per provision of law, and he was allowed to go on bail as pray for. After examining the witness before the charges and after hearing the learned counsel, both sides having found prima facie material under Section 7 of EC Act 1955 against that accused person, charges under the said sections was framed and read over and explained to which he pleaded not guilty and claimed to be tried. Therefore, that the prosecution is support in its case examined as many as 4 witnesses in that form of one complainant, Your Lordship, Nakibur Rahman Borbora, 2 Ramesh Agarwal, 3 Rajen Prasad Sil, and 4 Amit Chaudhary. After closure of prosecution evidence, the accused was examined under Section 313, wherein also he denied the allegations leveled against him. He also denied to adduce any evidence in his defense. I have heard that argument advanced by learned counsel for both the side. During the argument, learned APP has stated that the prosecution has been able to prove that the charges level against the accused persons beyond all reasonable doubt. Not on the other hand, the learned defense counsel has argued that the prosecution has miserably failed to establish the allegation offense. LS offense. He has further argued that the prosecution has not only failed to prove that the accused person is that the owner of that Prakash Hotel, but also failed to prove that the fact that the articles seized were in fact the seized from the position of the accused person. He has further argued that the prosecution could not able to prove the accused person had used that cylinder in Prakash Hotel. He has further submitted that the PW 234 in cross examination have stated that they did not know from where that said articles were seized to which cast doubt in respect of seizure. Accordingly, the learned defense counsel has prayed for the acquittal of the accused person. On perusal of record during the preparation of the judgment, I have found that all the requirement particulars are not written in the charge from prepared by my learned predecessor. Although that charge was framed under Section 7 of that EC Act against that accused person, Perus of the offense report revealed that the allegation was respect to unauthorized and illegal possession of domestic gas cylinder, regulator, etc., and use that same for commercial purpose, which is violated the provision under order clause 7(1)(c) of LPG regulation supply and distribution, which is punishable under Section 7 of the EC Act. And therefore, after the hearing, both the side I deem it fit and proper to frame the charges, frame the same charge, phrase, and read over the same to that accused person accordingly. And I frame that same charges punishable under Section 7 of the EC Act against the accused person phrase. And that content of that charge are read over and explained to him, and him to which he plead not guilty, claim to be tried as claimed earlier. On being asked, the learned counsel for the accused persons that have stated that they have already cross-examined and further cross-examined all the witnesses for the prosecution, and they are not willing to cross-examine them anymore. After reframing the charges to date, it is further submitted that they are also not willing to adduce any evidence after framing the charges. Phrase the learned additional PP has also submitted that he is not willing to call any witness. That he has fairly submitted that in fact the charge is not altered, rather the same charge is framed and only the charge from is changed, stating the whole charges in clear terms. Point of determination. Now, sole point to be determined in this case, where the accused on or about 899 MS Prakash Hotel, Jorhat, was found to be using domestic LPG cylinder in commercial purpose, and that unauthorizedly and illegally possessing one empty cylinder, one partly used LPG domestic cylinder, one commercial regulator, rubber pipe, and thereby violated the clause of 171C of LPG regulation supply and distribution order 2017. Thereby that committed the offense of punishment under Section 7 of the EC Act and within my cognizance. Discussion and decision, Lordship. PW1, Nikibur Rahman Borbra, the complainant, deposed that since the year 2007, he had been working as an inspector in the Food and Civil Supply Consumer Affairs Department at Jorhat. On 899, as per the direction of the director of that his office, he along with Inspector Lal Chandra Bori, Jitan Gogoi, Arun Sharma, Sub Inspector Jageshwar Sharma, Sapna Mahanta went to the hotel of the accused under the name and style of Prakash Hotel situated at Raja Maidam Road, Jorhat, for inspecting to whether the hotel was using the commercial LPG cylinder or not. On inspection, they found that the hotel was using LPG cylinder meant for domestic purpose, and they also found they are empty. They also found there one empty LPG cylinder meant for domestic use. Then they asked the accused person show the valid document in using the same, but he failed to show any domestic document to that effect. Then they seized 2 cylinder, 1 regulator, and 1 LPG pipe. Exhibit so and so, Your Lordship. Thereafter, they gave the seized cylinder in the custody of the one Rajendra Prasad Sil, manager of that MS Lavanya Gas Agency. Exhibit so and so. Thereafter, they took that regulator and LPG pipe along with them. Subsequently, he filed a FIR at Exhibit 3 before the joint director with his signature. Thereafter, he submitted the offense report, Exhibit 4 with his signature, Exhibit 4.1 to the Deputy Commissioner Jorhat, who forwarded the same to that court. He proved the Exhibit 5 to the forwarding letter, the offense report to the Deputy Commissioner Jorhat to the court in cross-examination, Your Lordship. PW1 stated that he along with that offense report has not been annexed the order directing them to inspect that Ellis hotel of the accused. The defense to cross-examine put that following suggestion on the PW1 complainant and the accused is not the owner of the MS Prakash Hotel, Your Lordship. That he has not seized the regulator and LPG pipe from that position of the accused. see that he has not seized the cylinder from the Prakash Hotel. The C cylinder was not used in Prakash Hotel. The PW1 had not even entered inside the Prakash Hotel. And that he did not make any search in the Prakash Hotel. That the accused saw him the blue book LPG connection, but PW1 did not seize. Ace that the accused was lawfully possessing that seized cylinder, and PW1 has failed.
These are all evidence.
Lordship.
Now,
Lordship,
now,
here I'm-
now,
Here I am
it looks like you are trying to build your case on the cross-examination part,
Lordship.
where you have taken out from the cross-examination that you have not done this, you have not done this, right? I will hear you, Gogol,
Lordship.
but this looks like that. But what is clear is that the complainant,
Lordship.
after getting some information when had visited, they found that you were using as a domestic cylinder in the hotel premise, whatever
Palace.
dhaba or whatever that restaurant is,
Lordship.
right?
Lordship.
Now you fail to give those papers.
Lordship.
In
I'm
the
coming to that, Your Lordship.
in the evidence, the complainant clearly says
Lordship.
you are the owner.
Lordship.
He has said, now owners will be on you because you admit that burden lies on you.
Lordship,
They
I'm
have
coming to that.
probabilized it.
Lordship.
The foundation facts has to be there.
Lordship.
Prosecution has brought it
Lordship.
that yes, you were found in the premises A. Secondly, it's a commercial premises where LPG gas has been, domestic LPG gas has been used for commercial. These foundational facts has been proved by the prosecution.
Lordship,
Now they are saying it is you. If you want to take the plea, no, I'm not the owner. No, I am not responsible. Then that burden is on you,
Lordship,
isn't it?
I'm coming to that, Your Lordship. Let me reply, Your Lordship.
Yes.
First, Your Lordship. Here, Lordship, I'm categorically denied that I am not the owner of that hotel. Lordship, in the municipal area, Your Lordship.
Where have you denied?
Lordship, that I'm suggesting
In your
there.
313 suggestion, you have not denied. Suggestion are suggestions.
Lordship, also it's
In
corroborated-
313, have you denied?
Lordship, in suggestion,
Are you answer my question?
Lordship, that
Have you denied in 313?
313, I'm denied, Your Lordship.
Where?
Lordship,
Show me 313.
313 is not.
Where is
corresponding
the
to-
explanation in 313? What is the explanation? General denial.
Nothing. Only general.
Correct, I've seen it. Where is the explanation in 313? Where you see 313 is what?
Lordship.
It is that because you do not have you cannot say your what you want to say, right? As a defense, as the accused. So an opportunity for the first time is given to you, where all the incriminating circumstances are put to you, and your explanation is called. Now, have you clarified in your 313 what were you doing there?
So I'm clarifying, Lordship.
In
Let me
313, not
reply.
anywhere else.
313 also, Lordship.
Answer the specific question. In 313, what is your explanation? Have you adduced any evidence?
No, Lordship.
That is why I'm saying you are building your case on your cross-examination, where you have given suggestions. And they have denied the suggestions.
Suggestion is also corroborated by one of the.
Where is
one
your
of PW
evidence?
One of PW's, Lordship. Corroborated by one of PW's. They are the prosecution witness, Lordship.
What?
Was I'm coming to that, Your Lordship.
Yes.
Let me explain, Lordship.
Yes.
In a municipal area, Your Lordship, even you are running at roadside stall, Your Lordship. If you seen Guwahati, Your Lordship, even roadside have also one certificate which is provided by the municipal board, Your Lordship. Even here, the Lordship, they have not seen any kind of certificate. Lordship, that's clear, Lordship. And next part is that I'm denying that I am not the owner of that hotel. And which is that the suggestion is also there, and which is corroborated by the PW from probably 4. I'm coming to the Lordship, PW 4 or 3, Your Lordship. Lordship, who are the seizure witness, Lordship? Seizure witness is also not corroborated by that PW1, Your Lordship. PW1, Your Lordship, who search has been made, Your Lordship, under order which is reflect in that FIR copy, your lordship. If you go to that FIR, lordship, FIR copy is there, lordship.
Before that, one second. Yes.
Lordship, exhibit lordship 3, your lordship, FIR. That is on record, your lordship. Here clearly mentioned, your lordship, in pursuance of order dated 7/9/2009, I along with so and so, your lordship, visited the Prakash Hotel, your lordship. That order is a vital part of the evidence, your lordship. That has been not annexed. That has been never shown to me, your lordship. That order, what contains, your lordship? Either that directly addressed to me or as a whole, your lordship. That has been not been produced, not been exhibited by the prosecution, lordship. And next thing is, lordship, PW1 regarding the, your lordship, PW1, where he visited or search met, he have to maintain a one diary, your lordship. Here in this case, your lordship, he have not maintained any single diary, also any single entry, your lordship. And your lordship, he has not been seized any document regarding that, regarding the ownership of that hotel, your lordship. And regarding that, my suggestion is there, and the lordship, which is corroborated by the lordship. May I read the lordship, PW 2, 3, and 4, your lordship?
Evidence is not required. We are not seeing the evidence. It is already there in the judgment.
Yes, lordship.
Yes, I have already seen that.
The lordship.
This court is not going to appreciate those evidence. Minimum, whatever is to be seen has been seen from the judgment. Why are you not understanding in which jurisdiction you are right now facing, Mr.
Your lordship,
Gogoi?
I'm just
How many
evidence.
more hints do you need from this court?
Evidence, how it's appreciated.
Correct. I've been hinting, but you have to take it now. You're a member of the bar.
Lordship,
You
I'm
must
learning,
know
your
where
lordship.
to, at what point you will have to give it up.
Mainly point is this, lordship. My point is that, lordship, prosecution has been not prima facie established.
Very well, noted.
Lordship, no, which is corroborated from the evidence, Your Lordship,
Very well.
which has not been appreciated by the Lordship, the trial
Appellate
court,
court.
and as well as the
Very
appellate
well
court,
noted.
Lordship. No, which is, can be clearly seen from the evidence. That is also.
Very well.
That is, and Lordship, regarding that burden of proof, Your Lordship. Burden of proof, I have brought one judgment, Your Lordship.
Yes. Give me section 14.
Section 14 is there, Lordship. Burden and that to when onus can be shifted,
Yes.
Lordship. Here in this matter, Lordship, in NI case, Lordship.
Where a person is prosecuted for contravening any order made under section 3, which prohibits him from doing any act or being in possession of a thing without lawful authority or without a permit, license or other document, the burden of proving that he has such authority, permit, license or other document shall be on him. Yes, give me the decision. Come on.
Probably, Your Lordship, para 17 onwards, Your Lordship.
This is what I indicated, that particular initial fact has to be proved by them. That proof, according to me, is the possession of the gas cylinder. That they have shown. Now, the moment it is shown that you were possessing that, because at that moment you were there, that much they have given,
Lordship,
which is not denied by you by giving any explanation in your
Lordship,
313.
Lordship, that point, I'm completely denying that is not mine.
Okay, noted.
Lordship,
Noted.
which is
Yes.
from that-
Anything else?
Clear from that the PW's Lordship.
Anything else?
Court of Lordship and
Don't repeat anything else.
Lordship and alternative price provision, Your Lordship.
That I've heard you
Lordship-
yesterday.
Lordship, I'm again, Lordship. And,
You have relied on that Supreme Court
Lordship,
judgment.
yesterday I relied that to all judgment. I have
Now
brought
show
it
me from
new-
the records, where have you shown or given any evidence that you have a good character or you have been behaved properly before the trial court or the appellate court?
Yes,
Where is that part?
Uh,
Except that you are a first time offender, which
First
you are,
time offender,
that
That is enough.
part, what is there?
that enough, Your Lordship.
That is enough.
That is enough.
That is your submission.
Yes, Lordship.
Okay,
I'm
noted.
not a hardened criminal, Your Lordship. Not
Alright.
not a selling or smuggling the cylinder.
very well,
I'm using
noted.
for my livelihood, Your Lordship.
Noted.
Lordship. Here in the latest judgment, Your Lordship.
Matidiba,
Here in the Lordship
Pranava Matiba.
contained Lordship.
Yes.
Para 8, 9 and 10, Your Lordship. Even if, Your Lordship, there is no scope for interference regarding that trial court as well as the appellate court judgment. Even then, also, Lordship can invoke that provision of offender, Your Lordship. That provision, Your Lordship. All matter 2009, Your Lordship, 1.5 decade has been gone, Your Lordship. I'm suffering a lot, Your Lordship. And one thing is that, Lordship, I came before this court, Your Lordship. One day as well as the fine, Your Lordship, 20,000. 20,000 means a lot for me, Your Lordship. It's a huge amount. I'm roadside vendor.
Before you should have thought about it before using that cylinder for commercial purpose.
No, Lordship, I'm
You that if this court upholds the conviction, that means that conviction is upheld. Now you are arguing the question of
That's my
extending the
alternative
benefit.
argument, Your Lordship.
So
That's
when
okay.
you are arguing the alternative benefit, then don't say that.
Lordship,
Then don't say that part.
Lordship.
Because then what is the use of prescribing any punishment for such offences Most of these people will be first time offenders. They are not going to be hardcore criminals using gas cylinders for commercial purposes. They will be obviously running their own businesses. But that means but that is an offense under the EC Act, under the Distribution Act, because some revenues are generated for some specific purposes. These requirements are made in law that what is for commercial purpose, how the registration has to be done for domestic or commercial. These are made. This has to be followed. Now, in every such case, if the offenders come before this court and say, no, I'm not a hardcore criminal, I'm a first-time offender, I'm doing it for my livelihood, so do not give me any fine, do not give me any imprisonment, just leave me.
Lordship,
Then what is the requirement for prescribing any punishment for these people?
Lordship, I'm not.
So don't make that kind of an argument. You want, and that is why this court was again asking you, is there anything on record to show that you are of good conduct? That apparently is not there in the appellate court judgment or in the trial court. If it is yes, say yes. If it is no, say no. I have already heard your first
Lordship.
about the first time
Lordship,
offender.
after Lordship.
That I have consumed.
Lordship,
So when you are asking something, give the specific answer.
Lordship,
Not the same thing. Repeating of the same thing will not get you anywhere.
Lordship.
Date of occurrence is when?
2009, you'll say 8/9/2009.
2008?
9. 9.
8909.
Anything else?
Lordship, that's all.
Yes.
Lordship, so far, this case is concerned, my lord, because seizure list is very much clear, my lord. It's stated as I am reading, my lord. Seized from the following articles from the business premises of Prakash Hotel from the possession of Satyanarayan Sharma, my lord. 2 cylinders and 1 commercial regulator, my lord. This seizure list is there, my lord. He has not challenged this seizure list, my lord. That proves, my lord, the initial burden from the prosecution, my lord. After that, my lord, PW1, by going for the evidence of PW1, my lord, as everything is clear that on that day, my lord, he has visited the hotel and seized those cylinders, my lord. And after getting seized those cylinders, he has given the Jimma of those cylinders to one Ram, another person, my lord, that is one Rajen Prasad Sil, my lord. In his evidence, he has corroborated that the cylinder was given to his Jimma, my lord, after seizing, my lord. So evidence wise, my lord, everything from PW1, PW4, it is there, my lord, that he has used these cylinders for, my lord, commercial purpose, my lord. And PW, again, my lord, going by the, my lord, as he's saying, my lord, he's not the owner, there is no DW to that effect, my lord. And he's not the owner, and it is seized from him along.
Where's the
seized-
313 is with you?
Yes, Lordship.
Can you read that explanation part?
Explanation is.
What is
nothing.
it? It's blank or
Only
what?
none, only the nine,
No, no. In that question, if you have to,
Yes,
that
question.
last question,
Lordship.
what do you have to say? There is a question, no?
Yes.
What does he say?
সাক্ষী আগত সাক্ষাৎ 8-9 তাৰিখে ৰজা মৈদামৰ প্ৰকাশ চোতালত ৰাখিছিল, চিলিণ্ডাৰ ৰাখিছিল। আপুনি কি কয়? এইটো মিছা কথা।
No, I'm not on that.
Yes.
These are all denial,
Denial.
right? But at the last, at the end, there is one question, no?
Yes, but last question also. সাক্ষীবাদী সাক্ষাতত LPG গেছ আৰু ৰেগুলেটৰ ভাইলেশ্যন কৰি এসেঞ্চিয়েল কমোডিটি এক্ট সেকশন 7ত দিয়া হৈছে। উক্ত বিষয়ে আপোনাৰ কোৱা মই দুখী নহয়।
He simply denied.
He simply denied.
No explanation.
Yes, no explanation.
Okay. Anything else?
No, but that is that.
But Mr. T. Gogoi, na?
Lordship, T. Gogoi.
T. Gogoi, learned counsel appearing for the petitioner, also heard Mr. MP Goswami, learned APP for the state respondent. By way of the instant petition under section 401, read with section 397 of. You write it like this. The petitioner has filed the present criminal revision petition under section 401, read with section 397 of the criminal procedure of the Code of Criminal Procedure 1973, assailing the judgment and order dated 4/3/2013 passed by the learned Chief Judicial Magistrate Jorhat, hereinafter referred to as the trial court, in CR case number 348/2009, whereby the accused petitioner was convicted under Section 7 of the Essential Commodities Act 1955, hereinafter referred to as the said Act, and sentenced to undergo rigorous imprisonment for 1 year and to pay fine of rupees 20,000 only in default of payment of fine to undergo simple imprisonment for 3 months, comma, and further assailing the judgment and order dated 29/9/2014, passed in criminal appeal number 11/2013 by the learned Session Judge Jorhat, within bracket hereinafter referred to as the appellate court, whereby the conviction whereby the appellate court partly allowed the appeal by upholding the conviction. However, modified the sentence to imprisonment till the rising of the court and to pay fine of rupees 20,000 only in default of payment of fine, simple imprisonment for 3 months. Okay. The prosecution case in brief is that upon a joint inspection, it was found that the petitioner was using a domestic LPG cylinder for commercial purpose in violation of the control order attracting the offense under Section 7 of the EC Act, of the said Act, so and so. Based on the said inspection, the complainant stroke PW1 lodged the complaint, which led to the prosecution of the petitioner. Both the courts, both the trial court as well, both the trial court and the appellate court, on appraisal of the evidence on record, held the charge to have been duly proved. Situated thus, the present criminal revision. Mr. Gogoi so and so urge and submits that the prosecution has failed to establish beyond reasonable doubt the facts giving rise to a presumption under Section 14 of the said Act so and so. He accordingly submits that until and unless the prosecution proves the facts in order to give rise to a presumption under Section 15, the onus does not shift to the accused to prove the contrary. In support of the aforesaid submission, he relies upon the decision of the coordinate bench of this court in the case of Manik Lodh versus State of Assam and others, reported in 2007, Volume 3 GLT 207. He further submits that the trial court as well as the appellate court committed grave error of law as well as in facts in convicting the accused petitioner under Section 7 of the said Act so and so. He further submits that there are several contradictions among the prosecution witnesses regarding the alleged recovery of LPG cylinder, which were not at all considered by both the courts while passing the impugned judgments. He further submits that both the courts fail to appreciate the fact that the accused petitioner is not the proprietor of the Prakash Hotel from which the LPG cylinders were alleged to have been recovered. He further emphasizes that it is clear from the evidence of the PW2 and PW3 that the accused petitioner is the proprietor of Sagar Hotel, and not of Prakash Hotel. He further submits that both the courts did not take into consideration the vital aspect of the matter, that the complainant stroke PW1 had carried out search operation in various hotels and restaurants of that particular locality and seized some LPG cylinders, but did not keep any record or diary for the same. He further emphasizes that none of the seizure witnesses have ever said in their evidence that the LPG cylinders in question were recovered from the possession of the accused petitioner, that is, from Sagar Hotel. He further submits that the accused petitioner has successfully discharged its burden of proof by demolishing the case of the prosecution with effective cross-examination. However, both the courts did not appreciate the same. He further submits that the benefit under Section 360 of CRPC was not given to the accused petitioner by the both courts while passing the impugned judgments. He further submits that the appellate court recorded appellate court, though reduced the sentence, however, did not extend the benefit of Section 360 of CRPC or Probation of Offenders Act to the accused petitioner. He further relies upon the decision of the apex court the one which you gave me yesterday. What is that citation?
That was 2005, Your Lordship. Two 10 SSC 330.
Relied upon the decision of the apex court in so and so, reported in
2005 10 SSC 330.
and Taraknath Keshari versus State of
West
Bengal,
Bengal.
reported in
Lordship, independent Lordship, the citation to
Yes,
2023 INSC 513.
itu diba 2000 INSC means what? Manupatra.
No, Lordship, it's a Supreme Court, Lordship. Supreme Court equivalent citation independent.
Reported in 2023 volume 8 scale 109. Scale I think is more known.
Lordship.
I don't know what is INSC.
It can be seen from the Supreme Court website, Your Lordship.
Anyway, so many nowadays,
Lordship.
but I'm not familiar. I don't know if you all are familiar with INSC. Scale I am. Yes. Per contra, Mr. MP Goswami, Leonard APP for the state respondent submits that the prosecution has clearly proved the seizure of the domestic LPG gas cylinder from the hotel of the petitioner in his presence from the hotel of the accused petitioner in his presence, and has also proved the same by adducing the evidence of the complainant himself. Stop. He further submits that since the prosecution has proved the facts necessary for giving rise to the presumption under section 14 of the so and so act, the onus thereafter is on the accused petitioner to prove the contrary. He further submits that the accused petitioner, apart from giving suggestions during the cross-examination of the prosecution witnesses, neither offered any explanation whatsoever as regards to the alleged seizure of the LPG gas cylinder, domestic gas cylinder from the hotel premises in his presence, nor adduced any evidence whatsoever in support of his defense, so as to rebut the presumption in law having been raised against him. He further submits that since the appellate court has already considered has already reduced the sentence imposed by the trial court, no further leniency, no further interference as regards the sentence is warranted, considering the serious nature and circumstances of the offense. Stop. Correct? I have given my prudent consideration to the learned to the arguments advanced by the learned counsels appearing for the parties, and have perused the material available on record. I have duly considered the case law cited at the bar. In the present case, the offense involves misuse of domestic LPG cylinders meant for household consumption, which is an act the legislature treats as a matter of economic offense, impacting public distribution. The appellate court, no, go back. It appears that the PW1, the complainant, deposed that since the year 2007, he had been working as an inspector in the Food and Civil Supplies and Consumer Affairs Department in Jorhat. He further deposed that on 8/9/2009, as per direction of the Joint Director of his office, he, along with Inspectors Lalchand Bori, Jiten Gogoi, Arun Sharma, please find out if any of them are PWs, and Sub-Inspectors Jageshwar Sharma and Sopan Mohanta, page 13, went to the hotel of the accused petitioner under the name and style Prakash Hotel, situated at Raj Maidam Road, Jorhat, for inspecting whether the hotel was using commercial LPG cylinders or not. He further deposed that on inspection, they found that the hotel was using an LPG cylinder meant for domestic purpose. He further deposed that they also found there one empty LPG cylinder meant for domestic use. He further deposed that upon them asking the accused petitioner to show valid documents in using the same, comma, the accused petitioner failed to show any document to that effect. He further deposed that thereafter they seized the two cylinders, comma, one regulator and one LPG pipe by Exhibit 1 and further exhibited his signature therein. He further deposed that after seizing the cylinders in the custody of the Caesar witnesses, Rajendra Prasad Seal,
Yes,
Yeah.
Rajendra Prasad,
Yes.
PW,
PW, my lord, 3.
PW3,
3. PW 3. Rajendra Prasad Seal.
his
Say, my paragraph
Look,
4
stop,
of the.
stop.
Judgment.
He further deposed that they also took the regulator and the LPG pipeline along with them. He further deposed that thereafter he filed the FIR on the same date, no?
Not
Yeah, on the same day.
On 8/9/2009 and exhibited the same as Exhibit 3 along with his signature as Exhibit 4.1. No, Exhibit 3.1. He further deposed that thereafter he also submitted the offence report to the Deputy Commissioner Jorhat and who forwarded the same to the court. He further exhibited all the other official documents. During cross-examination, he clarified that he along with the offence report has not annexed the order directing them to inspect the alleged hotel of the accused. He further clarified, though the defense had put the following suggestions to him, however, I got page 14 A to H Baba. Hikini etake diba semicolons di or last dot semicolon dibaga. However, he denied all the above suggestions. Bujhi pala? He further clarified that he did not maintain any diary while seizing the articles, nor ask for any document. No, this is itar agor etu kori diba. এই 9 চাই ল'বা হা ইয়াতো কেইটামান আছে এইকেইটা ক্লাৰিফাইড বুলি গোটেইকেইটাই কৈ দিবা PW2 is the Caesar witness.
Yes, ma'am. 2, 3, 4, all are Caesar.
PW2, 3, 4 are the Caesar witnesses
Yes.
who have deposed that in the year 2009, the officials from the supplies office seized some articles from the possession of the accused. Page 15 or so. Clause 7 of liquefied petroleum gas within bracket. This is that order you were mentioning yesterday.
Lordship, that,
Clause 7, no?
yes, sir.
Clause 7 of liquefied petroleum gas within bracket regulation of supply and distribution within bracket order 2000 provides prohibitions in respect of possession, supply or sale of liquefied petroleum gas equipments. Subclause 1C provides that, quote unquote, kore diba, huh? It appears that though the no, it appears section 14 of the so and so act provides as under, quote unquote, ESA. Under the ESE Act, when a person is prosecuted for contravening any order made under section 3, I got to me section 3 section 3 of so and so, then section 14, huh? Quote unquote 14. When a person is being prosecuted for contravening any order made under section 3, the burden of proving that he has such authority, permit, license or other document shall be on him. The Mr. T. Gogoi, learned counsel appearing for the appellant, is correct that the initial burden of the prosecution to establish the facts giving rise to the aforesaid presumption under section 14 of so and so beyond reasonable doubt shall be upon the prosecution and only shall be prosecution. Stop. However, once the prosecution establishes the facts in order to give rise to the presumption under section 14, the onus shifts to the accused petitioner. In the present case, the prosecution has clearly proved that the accused petitioner was using 2 LPG gas cylinders now clearly proved unauthorized and illegal possession of domestic gas cylinder, comma, regulator for commercial purpose, intended to be used for commercial purpose. Stop. The same is in violation of the provisions of the order or provisions of clause 7(1)(c) of the aforesaid order, which is punishable under section 7 of the so and so act. Once the prosecution has proved the said fact of the accused petitioner possessing the aforesaid unauthorized domestic gas cylinders, the onus heavily lies upon the accused petitioner to prove the contrary. It is further apparent that upon the accused petitioner being asked as regards the documents, permit, license, comma, he could not produce any. That apart, in his 313 examination, he has not offered any explanation whatsoever as what he was doing with the seized domestic gas cylinders from his hotel. Though by relying upon a cross-examination to indicate that he is the owner of one Sagar Hotel, comma, the same has no consequence inasmuch as there is nowhere on record to show that he is not the owner of the Prakash Hotel from where the gas cylinders have been seized from his possession. Neither has he given any explanation, nor any documentary proof, or any other evidence before the trial court to prove the contrary. That being so, it is clearly established that he has contravened the provisions of the order so and so, and hence a case under section 3 is clearly being made out. The conviction of the trial court does not appear to be perverse or illegal or erroneous in law. Stop. It appears that the appellate court has also analyzed the evidence in proper perspective, and after recording reasons was pleased to modify the sentence to imprisonment till rising of the court. This court is mindful of the limited scope of revisional jurisdiction under section 397 and 401 CRPC. Interference is warranted only when the findings suffer from jurisdictional error, comma, patent illegality, material irregularity, or perversity. Upon examining the record, this court finds no illegality, infirmity, or perversity in the concurrent finding of guilt recorded by the two courts. The essential ingredients of the offense stands duly proved. As regards the contention of the learned counsel, for extending the benefit under section 360 of the CRPC or the of Probation of Offenders Act, it appears that the appellate court, after considering the decision of the apex court in the case of Hari Vallabha Supra, found no adequate justification to extend the benefit of probation. As stated above, the appellate court has already substantially modified the sentence to imprisonment till the rising of the court, which according to this court is proportionate and considerate, having regard to the nature and circumstances of the case. Hence, no ground is made out for further interference in revisional jurisdiction. For the reasons aforesaid, this court finds no merit in the present criminal revision petition. Accordingly, the criminal revision stands dismissed. The judgment of conviction and the modified sentence imposed by the appellate court are hereby affirmed. Pending applications, if any, stands disposed of. Sorry, Mr. Gogoi.
It's okay.
এখন দি দিব তো কিতাপখনৰ এটা প্ৰিন্ট লৈ ল'ব, প্ৰিন্ট লৈ পেলাই দিব আৰু এইকেইটা তাক দিব। এইখিনি ইয়াক লাগিব।
Number 16.
Why is there a confusion as who will start?
No, I thought that maybe, Lordship, in this Lordship, PW2. PW2,
যাব
Lordship.
পৰা।
Lordship, I'm sorry, PW3, Lordship. PW3, shall I read, Lordship? My name is Gautam Chetri. I know the accused by name and person. I look after the 709 bus, the bus in which the cannabis was found, Lordship, along with the accused, bearing so-and-so. The owner, so-and-so is my father. The bus,
Who is
Ra-
PW3?
PW3 is the
Owner of the bus.
Is the owner.
owner of the bus is his father. He's the son who
Yes.
look after the bus.
Yes, yes.
About 1.5 years back, on the day of the occurrence, I was at home. On that day, the bus was bringing passenger from Dimapur to Tejpur. The driver of the said bus, PW2, who is the driver,
This you are reading from the trial court records.
Lordship, which was translated, call me over phone from Methoni and inform me that one passenger, he immediately, the driver, Lordship,
Have you given copies of these? to the court?
Lordship.
Where are they? No copy book what is?
The main appeal.
Lordship, in main appeal, there is translation part of the Lordship, already
Page
flagged.
68. At the time of filing, Lordship, I have
60?
page 68.
Yes. Yes.
Lodge. PW2. PW2
Sure.
call me, PW3, but.
Yes, I am in page 68.
PW2
Call me over phone.
over phone from Methoni and informed me that one passenger of the bus was bringing cannabis from the police. Cannabis and police have taken him to Bokaghat police station and asked to come early. Then I can, so that means Lordship, when he was, when the police seized the bus Lordship, then he was caught, then immediately that driver rang the owner Lordship. So there is a link Lordship that he was the person, because in 313 the accused denied Lordship that he had boarded the bus Lordship. I'm going only to the relevant portion Lordship. And Lordship, in PW2, Lordship, now I'm coming to PW2, cross part Lordship. In chief, he have already said that the accused had boarded his bus with a bag. In the cross part Lordship, at the time of stopping our bus by the police, it was fully packed with passenger. I do not know what bag the accused boarded, but I was driving at
This is an appeal, no?
Appeal, Lordship. But Lordship, in the second part, Lordship, he have said, police unboarded me also while checking the bus at Methoni. They checked the bag of the accused. In the cross only, Lordship. Once he have said that I don't know what bag he is.
Where is that part?
Page is 65, Lordship, that is. In the cross part of PW2.
But I thought you were reading PW3.
Relevant portion.
No, you see, Miss Begum, once I hear, then I don't remember, because after hearing this matter, so many other matters in between, this court have heard and dictated judgment in the open court. How can you expect me to remember all these facts? So now you place them, because I'm going to dictate it right away. I don't like to keep these matters reserved because it makes no sense. I mean, it can be done in the court itself. It's more quicker to dispose of than keeping them. So you start from the first PW1. Let's read it again. Mr. Dave has already finished his part. Now you read it again.
Robert, page 6 and me to দিবলৈ হ'ব মোক।
You don't have the appeal memo.
No,
It's all there. Second copy, Naina.
May I read on our behalf?
Yes.
PW1 of it.
In case you need to say something, you say it, because I'm hearing you, huh, Ms. Begum?
Lordship.
Huh.
I do not know the accused present today. One day, about 1.5 years back, at about 3 o'clock in the evening, I was in my fruit shop, which is situated near in the Bokaghat police point. At that time, one police personnel took the weight scale of my shop and also took me to the Bokaghat police station. There I saw 2 larger paper boxes. When I was told to weight the said 2 boxes, I weighed the same. Police seized my weight scale by Exhibit 1. Exhibit 1 is my signature. After weighting the articles, police gave custody of the seized weight scale back to me. Exhibit 2 is the Jimma number. Exhibit 1 is my signature. In cross part lottery, one packet weighted a bit more than 2 kg. The other weight same.
Okay.
I
So
did not-
one is a Caesar witness.
Caesar-
And you were emphasizing that one packet was weighing more than 2 kg.
Little bit more than.
Yes. Okay.
Originally, it was seized as per Caesar 20 kg 800 grams.
What
Okay.
is Lordship? What
Well-
PW1 statement, Lordship? The judgment was passed that it is medium, not commercial. According to his weight, 4 kgs, Lordship, as it was.
Intermediate.
Intermediate. Then PW2, Lordship.
May I read the PW2? I can identify the accused Sapwali, who is in the dock divers, page 64. I can identify the accused Sapwali, who is in the dock. About 2 years back, I was driving a passenger bus bearing number 05A0774 from Dimapur towards Tezpur, and I reached Ragajan at 9 a.m. Then the accused boarded our bus with black colored bag, Lordship. Black colored bag. The said bag was large. On reaching the Mathoni after crossing Bukarat, police signaled our bus to stop. Police searched our bus, then Papuali handed over his bag to police. Police unboarded all the passengers while searching the bus. The bag of the accused was checked by police wherein they found cannabis. Thereafter, along with the accused, we were all brought to Bukarat police station along with the bus. At the police station, we were released and the accused was kept. Police found cannabis weight 20 kg 800 grams from the accused. Police took my signature at Exhibit 1, seizure list. Sri Keher Singh Chhatri is the owner of the bus I was driving. He resides at Jakhlabanda. The bus plying from Dimapur to Tezpur. The cannabis was inside the bag in 2 packets. I came to know the accused name in the police station. The police took my
So
signature.
2 is also a Caesar.
Seizure.
Caesar
driver.
come driver. He
And-
is Caesar come driver.
His cross-part is important, Lordship. At the time of stopping our bus by the police, it was fully packed with passengers. I do not know.
Papuali is the accused.
Yes,
Papuali is
Papul is the accused. I do not know what bag the accused boarded the bus. In a chief, he said black color.
It's all right.
Yeah,
He may not see.
Yes,
You
Police
see,
are-
how will the driver see who is come with what bag? But he said he saw Papuali handing over his bag to the police.
the black color bag. Earlier he stated before in chief, Lordship.
The bag of the accused was checked by the police.
No, before that there is a line, a black color bag.
That he saw. Then the accused boarded our bus with a black colored
Yes,
bag.
yes, Lordship. Police unboarded me also while checking the bus. At Mathoni, they checked the bag of the accused, but they did not check the contents of the packet that were inside the bag. They opened the weapon and weighed the packets at the police station. Police interrogated me. I did not say it before the police that after unboarding the bus, the accused handed over the bag to police.
But there is some one word, Lordship. That word, Lordship, I have gone through all the. We are not able to find out what word is that because police move nomai sil basor in a cross part. Basor pora. Police bus check kori Mathonit basor bhitorot podokia. Then one word is there. The beggar bhitorot thoka packetot ki asil suan asil. One word is missing that we are not getting, let's see. Packetbur khuli tuaute সেই সময়ত মানুহজনৰ লগত ময়ো আছিল. The driver was
Present.
was present. And Lordship, the thing is that though he have said that I have not seen what bag he have carried, but immediately in the cross, he have said that unboarded me at Mathoni, they checked the bag of the accused. And the important thing is that Lordship, in 313, he have taken the plea that he have not boarded the bus, Lordship. But in Rangajan, another PW5 and PW6, though there are discrepancy, Lordship, but they have stated.
What is the discrepancy?
Discrepancy is that in the cross part, Lordship, they have in PW5, they have immediate.
Let's read the PW5 evidence, Lordship.
And he may have not said during the police that he saw the accused handing over the bag. After unboarding the bus, the accused handed over the bag to the police. That he may not have said it. But that is just an omission.
Yes.
Lordship.
Then may I read the PW5, Lordship? Page 74.
Mhm.
Page 74, PW5.
Page?
74.
No, but now, right now, who is arguing?
She's arguing, I am not
Let me read.
reading.
PW5, Lordship.
No, go serially. Go serially.
PW4 is not so relevant
Okay.
because he is the FSL.
He's the, let me take note of it. They are all here, no?
Lordship,
I'm just, PW4 is the FSL.
FSL, doctor.
Yes, then,
Lordship have got PW1 is the weighing.
yes, yes.
PW2 is the driver.
PW1 is the weighing, not the Caesar.
Shopkeeper.
Weighing and
Caesar,
seizure.
Caesar plus weighing.
Yes.
Caesar. He was the shopkeeper, PW1.
Yes.
PW2 is the driver.
Yes,
And PW3 is the son who
yes, sir.
is to look after the bus. And PW4 is the doctor.
Just
FSA.
read PW3 again.
Lordship, at about 1.5 year back, on the day of the occurrence, I was at home. On that day, the bus was bringing passenger from Dimapur to Tezpur. The driver of the said bus, PW2, called me over phone from Methodi and informed me that one of the passenger of the bus was bringing cannabis, and police have taken him to Bokaghat police station, and I asked to come early. Then I came to Bokaghat police station. I found the bus and the accused in the police station. I saw big packet being kept upon a table in the police station. There was 2 packet. They did not weight the packet in my presence. My signature was taken at the time of seizing of the 2 packets. Police seized the cannabis and the bus. Exhibit 3 is the aforesaid seizure list, and Exhibit 3.1 is my signature. Police kept the vehicle paper from me on the next day. After photocopying, I handed over the vehicular papers to the police. Exhibit 4 is the seizure list, and Exhibit 4.1 is my signature. And immediately he was also one of the seizure witness, Lordship. And the important thing is that he immediately knew from the driver, Lordship. The driver informed him. Maybe in cross he is saying, but in that time, Lordship, at relevant point of time, and this person was not cross, Lordship.
Here you cross.
Cross-calling.
Cross-calling. The packets that are seen today did not have covers like the
Sorry,
packet
Lordship.
I have seen in the table of the police station. The packets were open and contained cannabis. I did not see from where the said packets were recovered. I also did not see weighing
That one-
of the packets.
Saying in the chief Lordship that did not wait before in presence of him, Lordship. Now, Lordship, PW2. PW2 is the driver, Lordship. Lordship, I'll read whole Lordship.
Yes.
I can identify the accused Papu Ali, who is in the dock. About 2 years back, I was driving a passenger bus bearing so-and-so from Dimapur towards Tezpur, and I reached Rangajan at 9 a.m. Then the accused boarded our bus with a black color bag. The said bag was large. On reaching Mathoni, after crossing Bokaghat, police signaled our bus to stop. Police searched our bus. Then Papu Ali handed over his bag to police. Police unboarded all the passengers while charging the bus. The bag of the accused was checked by the police, wherein they found cannabis. Thereafter, along with the accused, we were all brought to Bokaghat police station along with the bus. At the police station, we were released and the accused was kept. Police found cannabis weighing 20 kgs, 800 grams from the accused. Police took my signature in the Exhibit 1 seizure list. That's so-and-so is the owner of the bus I was driving. He resides in so-and-so. The bus ran from Dimapur to Tezpur. The cannabis was inside the bag in 2 packets. I came to know the accused name in police station. Police took my signature in the seizure list. While seizing cannabis packet, Exhibit 3 is the seizure list and Exhibit 1 is my signature. Immediately it was seized and it was made exhibit, Lordship. And the cross chronology. At the time of stopping our bus by the police, it was full packed with passenger. I do not know what bag the accused boarded the bus I was driving at Rangajan. Police unboarded me. Also, while checking the bus at Mathoni, they checked the bag of the accused. It was particularly the bag of the accused, Lordship, which he have already said in his chief. But they did not check the contents of the packet that were inside the bag. They opened and weighed the packet at police station. After seizing, they have taken to police station where they have opened the packets, Lordship. Police interrogated me. I did not state before the police that after unboarding the bus, the accused handed over the bag to the police. It is a fact that I have falsely deposed. That line he have agreed, Lordship, that the bag was not handed by the accused to the police. I put my exhibit 3. One is signature at police station. It is not the fact that the police did not seize the bag and the 2 packets from the accused. It is also not the fact that I have given a false evidence today. So it is the fact, Lordship, that they have seized the bag from the accused and it was open in the police station, Lordship. That is a PW2. Now PW, Lordship, Lordship is the owner, Lordship.
PW5.
PW3, I will read now PW5, Lordship.
Yes.
PW5. He is the independent witness, Lordship. PW5. I know the accused person. I have forgotten how long ago the incident took place. On the day of the incident, I was traveling from Dimapur to Jokhalabanda on a public bus. At about 10:30 a.m., police from Bokaghat police station checked the bus in which I was traveling. From the said bus, they unboarded the boy along with a large cloth bag. On opening the said bag, the police found cannabis therein. Thereafter, the police sent away the said bus. I, along with the said boy and the bag, were brought to the police station. I cannot recall how much cannabis were found. After recovery of the cannabis, police took my signature on seizure list. Exhibit 1 is the seizure list and 1-4 is my signature. On that day, the boy who was apprehended by the police is the accused who is present in the court today. In the cross. I do not know whether the said bags belong to the said boy or not. Lordship, he may not know, but the bag is there, Lordship, that the boy is bringing that bag or not. Exactly, Lordship, he may not say that. Because, Lordship, he was an independent witness.
Yes.
I came to know that the said bag contained cannabis, but the bag was there, Lordship.
Yes.
Only after seizure of the said bag by the police, I cannot seizure of the, he knew that it was cannabis after seizure of by the police. I cannot recognize the cannabis. I do not know whether the boy from which the said cannabis were seized and the boy who is present today as accused are the same person.
What's the name?
Lordship, by looking up boy one day, Lordship, in a full passenger bus, he may not recognize the face, Lordship.
Yes.
But Lordship, immediately the PW6 also said after
Can you read PW5 again?
full Lordship from
Just read again.
I know the accused person. I have forgotten how long ago the incident took place. On the day of the incident, I was traveling from Dimapur to Jokhalabanda on a public bus at about 10:30 a.m. The incident. Police from Bokaghat police station checked the bus in which I was traveling. From the said bus, they unboarded the boy along with a large cloth taking bag. A bag was taken.
You keep reading.
On opening the said bag, the police found a cannabis therein. Thereafter, the police sent away the said bus. I, along with the said boy and the bag, were brought to police station. Immediately they were brought, Lordship. I cannot recall how much cannabis were found. After recovery of the cannabis, the police took my signature in the seizure list. Exhibit 1 is the seizure list and 1-4 is my signature. On that day, the boy who was apprehended by the police is the accused who is present in the court today. Cross. I do not know whether the said bag belonged to the said boy or not. I came to know that the said bag contained cannabis only after seizure of the said bag by the police. I cannot recognize the cannabis. I do not know whether the boy from which the said cannabis were seized and the boy who is present today as accused are the same person.
Yes.
Yes, nothing.
All right, yes,
Then Lordship, PW6.
yes. See, because here the main facts has to be proved by the prosecution beyond reasonable doubt,
Lordship,
so as to give rise to that presumption in law.
Lordship,
Once the prosecution proves it, then the onus is on the accused,
Lordship.
right? So here, what is that you have proved?
First of all, he was in the bus, which he have denied in his 313 that I have not boarded the
Not
bus.
boarded.
The secondly, Lordship, there is so many passenger, Lordship. Only he, Lordship, along with that bag, Lordship. And the driver or the PW5 in their chief, they have never said, Lordship, that some other person were also carrying with bag.
So that's
Only
why
that-
you
that is the thing that
pinpoint these incriminating circumstances. Number one is that he was in the bus.
he was in the bus.
Number two is that he gave that packet to the police.
Lordship.
That has been seen.
Seen, and the driver immediately called his owner that a boy is caught with a bag and we are in the police station. And Lordship, the waiter, the shopkeeper, Lordship, from whom the scale was seized, he also immediately went there.
He also saw.
He also saw, and immediately, Lordship, they have signed the seizure witnesses, seizure list, Lordship, which were exhibited, Lordship.
So basically now if their stand is that he was not in the bus, he has to prove it. That he has not done.
He has not done.
So whether
There is no suggestion to the PWs by the defense that
he was not in the bus,
he was not in the bus and the bag doesn't contain to him.
that was not done.
Not done, Lordship. Nobody have denied that the bag was not his.
So for the first time in cross, he says he was boarded. Sorry, in 313, he says he has not boarded.
Not boarded.
That is for the first time in 313. No foundational in the cross.
Foundation, Lordship.
So
And
that-
Lordship, in 313, he have stated in question number,
That is a weak point, Mr. Dave.
Lordship, in
that-
PW6, Lordship,
Hmm.
I do not remember how I put the signature.
Those are procedure.
He have denied that it is not my signature on the one hand. On the other hand, he have said that I do not remember how I put my signature. That means it is his signature
Anyway, those are minor things, but
in the seizure list.
correct. Those are minor things, but ultimately, because you see, everything may not be fatal. You have to see what is fatal to the prosecution case. Now, here the main facts.
Main fact.
First of all, there cannot be any. I think I just dictated that part in in the earlier judgment.
Lordship.
The first part is always with the prosecution.
Lordship.
There may be presumptions in law,
Lordship.
but in order to attract those presumptions in law, you have to
Hmm.
prove the foundational facts
Lordship.
beyond reasonable doubt,
Lordship.
so as to give rise to those presumptions, right?
Lordship.
So here you have to show that
Lordship.
he was there,
He was there.
and from his possession.
Position.
Because in this situation,
Lordship.
had it been a conscious possession, then something more you may have to show, and then later on the onus goes to him that he did not have knowledge.
it will become clear, Lordship, if Lordship will read the PW6.
Wait. You will get your reply, Mr. Dave. Yes, Ms. Begum. Yes.
PW6, Lordship.
Junabali.
PW6
Yes.
is Junab Ali.
Hmm.
I do not know the accused Papu Ali from Agur. I have forgotten how long the incident took place. About 2.5 years ago, back, I boarded a bus coming from Nagaland towards Tezpur at Khatkati. At about 8:30 a.m., the bus picked up the passenger from Rangajan, and after crossing Bokaghat, the bus was stopped in a tea garden. The bus was checked. Police checked the bus. After unboarding us all from the bus, the police told that they have found cannabis inside the bus. The bus will not go. We were told to go on different bus. We boarded a different bus and came back. He is so important, but cross the line.
No. From whose possession, Lordship? What's his position?
Hmm?
Whose possession his bag was recovered? PW6 says that after unboarding all of us, police found there is a bag. PW2 and if PW5, the accused handed over the bag. Who is correct? Lord? It is not with not conscious possession of the accused, Lordship. In PW7 also stated that accused and the bag was inside the bus.
That's all right. He did not say anything more. Just because he said that unboarded us does not mean everyone. He may have seen everyone coming, but he may not know whether that accused petitioner was inside or not. See, Mr. Dev, I understand what you're trying to hint. It gives an idea that everybody is down. But if PW6 would have given also said that unboarded us and I have seen the accused petitioner waiting with us, then I could have understood. That is not there.
Only the people.
Yeah, so he said because he saw not only him alone, most of the passengers were coming down. So he said us. Nothing. There doesn't create any doubt in the mind of the court that the benefit will be given of that doubt to the accused. It says unboarded us all from the bus.
Yeah.
That is in his understanding. That there are other eyewitnesses who have seen you inside the bus handing over the bag to the police. Now, unless and until, of course, there are reasons for this court to doubt their veracity of that part, they have no connection with you. They are natural with the driver, the passenger. They are naturally they were there. The shopkeeper was in front of his house. Why should they implicate you falsely? And you have also not given any evidence to show you were not in the bus. Nothing given. A vague stand you have taken in your 313, I have not boarded the bus.
Yes.
But that does not discharge your burden under section 35.
3-1.
No, no.
Honorable Lordship.
Under the NDPS? 35? Is it 35? You understanding, Mr. Dev? That is a little narrow encompass area. You have to get out of that area. So you have to give me something more if you have to get out of that area. That they have miserably failed. Now that part from where do you say? See, some contradictions, minor here and there, procedural, can be. They're not fatal. 6, you are right. But that is not sufficient for the court to discredit the other 2 witnesses who have seen you handing over. PW1,
PW2.
2.
And he immediately informed his owner.
PW2 and 5.
Yes, those 2. PW2 says, I was driving a passenger bus and I reached so and so. Then the accused boarded our bus with a black colored bag. The said bag was large. On reaching Methoni after crossing Bokakhat, police signaled our bus to stop. Police searched our bus. Then Papu Ali handed over his bag to the police. Police unboarded all the passengers while searching the bus. The bag of the accused was checked by police, wherein they found cannabis. Thereafter, along with the accused, we were all brought to so-and-so along with the bus. At the police station, we were released and the accused was kept. Police found cannabis weighing so-and-so. Police took my signature, so-and-so, so-and-so, so-and-so. At the time of stopping of our bus, By the police, it was fully packed with passengers. I do not know with what bag the accused boarded the bus. I was driving at Rangajan. That is not sufficient to discredit what he said. He saw him handing over his bag to the police. Police unboarded me also while checking the bus. At Methoni, they checked the bus of the accused, but they did not, bag of the accused, but they did not check the contents. They opened and wait at the police station. I did not state before the police that after unboarding the bus, the accused handed over the bus to the back to the police. It is a fact that I have falsely, it is a fact that I have falsely deposed today that accused handed over the bag so and so. It is not a fact that police did not seize the bag so and so. So in cross, you have not said that you were not boarded. There's no foundation of that stand that you took in 313. So that is an afterthought. This court will not take that. Then 5. Let us see 5 again. I know the accused person. I have forgotten how long ago the incident took place. On the day of incident, I was traveling from Dimapur to so-and-so. From Bokakhat police station, checked the bus in which I was traveling. From the said bus, they unboarded the boy along with a large cloth taking bag. On opening the said bag, the police found cannabis therein. Thereafter, the police sent away the said bus. I, along with the said boy and the bag, were brought to the so. I cannot recall how much so and so. After recovery, so and so. So you see, 5 and 2 has to be read together.
5 and 2.
Lordship,
2 has identified you.
Lordship.
I do not know whether the said bag belonged to the said boy or not. I know because he doesn't know that. He have only seen you
See,
with the bag.
That is Lordship.
I came to know that the said bag contained cannabis only after seizure. I cannot recognize cannabis. I do not know whether the boy from which the said cannabis were seized and the boy who is present today as accused are the same. That is immaterial because he have already seen that boy.
Lordship.
He have said that boy, and accordingly the accused was the Caesar and everything. Everybody has seen you.
Lordship.
He may have forgotten by now.
Forgot.
You cannot expect him to. This is an independent eyewitness.
Lordship, in so many, after 2 years, one may forget. Lordship.
That's not necessary. But that doesn't discredit the fact because the other Caesar witnesses have seen you. Your presence have been identified by PW2 and the others. The shopkeeper.
Shopkeepers.
His shopkeeper is PW?
PW1.
Yes, Ms. Begum? What
It is-
more?
It's already clear, Lordship, that he was there. The cannabis was in his.
How did the trial court, what did the trial court rely?
Indictment.
Read para 16.
Lordship.
I have done so the above evidence on record from the evidence of PW7, Prema Fukon, the Inspector of Police, now Circle Inspector, who was at the time of incident was the officer in charge of the Bokakhat Police Station. He on the day of incident, that is 11/5/2010, intercepted 1709 bearing number S05A0774 coming from Dimapur to Tezpur on National Highway 37 of Methoni Tea Estate and searched the said bus and found 2 packets of ganja inside bag and seized the said bus and the packets under the seizure list. Exhibit 335 is the signature of the accused Papuali as deposed by PW7. The accused person did not deny the said fact that Exhibit 35 is the signature. PW7 specifically stated that accused Papuali was sitting inside the bus at the time of incident and the said incriminating bag was near him. The defense did not deny the said fact during cross-examination of PW7. Further, PW7 has denied the suggestion that he did not seize the 2 numbers of packets containing 20 kg 800 grams of ganja from the accused Papuali near Methoni Tea Estate while he was traveling as a passenger in the said bus. PW2 Mohammad Faizur Rahman, the driver of the said bus, has stated in his evidence that one day about 2 years ago, while he was driving the said bus from Dimapur to Tezpur on the way when he reached at Ragajan, the accused boarded into the said bus with a black color bag. The fact has not been denied by the defense during cross-examination. PW2 also stated that police checked the said bus NH37 near Mathonity Estate. Accused person took the said bag from the bus and alighted from the bus and handed over the said bag to the police. Police checked the bag and found ganja and took the accused along with the bus to the police station. The police found 20 kg 800 grams of suspected ganja inside the bag. This fact has not been specifically challenged or denied by the defense during cross-examination of PW2. In cross-examination, PW2 has stated that the police checked the bag belonged to the accused person, but he did not check the packets that kept inside the said bag. The police officer PW has specifically stated in his examination in chief that he found the ganja inside the 2 packets that kept inside the bag and took the accused person to the police station along with the bus. The fact has not been denied by the defense during cross-examination of PW7. When we read together the evidence of PW2 driver of the bus and the PW7 IO, we find that the police checked the bus on NH37 near Mathonity Estate and found the accused person along with the bag containing 2 packets of ganja amounting 20 kg 800 grams. PW5 Dipu Sharma was the passenger of the said bus. He has specifically stated in his evidence that at around 10:30 am, Bokagat police checked the said bus wherein he was traveling as a passenger from Dimapur. On NH37, one passenger with a bag used to carrying plots stepped down from the bus and police checked the said bag and found ganja. The police seized the said ganja under seizure list exhibit 3. Upon C3 is the signature. He has identified the said boy as a accused person in this case. Upon perusal of the seizure list exhibit 3, I find the signature of the accused person in the seizure list, which was exhibited as 3-5 by the police PW7. The accused person has not denied the said fact that exhibit 3-5 is his signature.
So
Exhibit
that is also proved.
That is answering.
Yes.
Exhibit 3
Exhibit 3 was prepared at the time of seizing the seized articles. The opinion of the scientific officer PW4 has not been challenged by the defense. There has been argument that the statutory provision of section 42, 52 and 57 of the are not complied with, but I find that there has not been any such non-observance, and further I find that non-observance of this section is the merely formality which has no force to vitiate the investigation or trial. There has been no arguments on the point of report of Forensic Science Laboratory Guwahati. The report is very much clear that the seized articles were ganja, when the seized articles were not in the person of the accused. Section 50 of the NDPS Act was not to be complied. The seized articles were in bag near the accused person when the same was seized by the police. From the above discussion, I find that the accused Papuali was arrested by the police after finding him with ganja while he was traveling in the 709 bus bearing number 05A0774. The quantity of ganja is 20 kg 800 grams. PW1 Shantipal has stated in cross-examination that quantity of ganja is more than 2 kg in each of the 2 packets. According to him, in total measuring 4 kg. The ganja has been weighed by him, which is less than commercial quantity but more than small quantity. But in the seizure list exhibit, it is mentioned the quantity of ganja is 20 kg 800 grams. The fact which is favorable in the accused person, it should be taken
So 4 is taken.
4 is taken.
from the evidence of PW1 Shantipal, who is with the ganja as per the instruction of the police. He found in total more than 4 kg of ganja from both the packets. Now it can be taken into consideration that the more than 4 kg of ganja has been recovered from the possession of the accused person. The quantity of ganja as per schedule of the NDPS Act is more than small quantity but less than commercial quantity. Therefore, the ingredients of the offence under section 20B2 capital B of the NDPS Act are found against the accused person, which is less serious than the offence under 20, small b, Roman 2, and capital C of the NDPS Act, under which the accused was charged. From the above discussion, I find that the accused Papuali was traveling in the 709 bus bearing registration number A05 A0774 on 11/5/2010, and the police checked the said bus on NH37 near the Mathonic Tea Estate and recovered more than 4 kg of ganja in 2 packets carried by him, and the sample of the same was sent to the Forensic Science Laboratory Guwahati for chemical analysis. The sample of ganja positive test for cannabis. Hence, I find that the prosecution is able to prove the case under section 7 of the NDPS Act against the accused person beyond all reasonable doubt. Accordingly, I convict the accused person under section 7. Had the accused person on the point of sentence, the accused is aged about 30 years, having his family members and hence prefer leniency. Yes. And then 24, considering all the this circumstance, I sentenced the accused person Papuali to undergo rigorous imprisonment for 5 years and with fine of rupees 20,000 only. In default payment of fine, he shall undergo rigorous imprisonment of another 1 year. Here, Lordship, in the FIR, Lordship, bus number was mistakenly given. So, para team 313, someone has given suggestion that you deny. It should be 7, but it should be, it was written as 0.
You are being fair.
Here, Lordship. But on the basis of 313, Lordship, aware that he cannot be. On the basis of 313, he cannot be. He cannot be convicted.
On the basis of?
313 statement.
But we are not convicting him on the basis of
Mm,
313.
But I try to, if prosecution establish their case beyond reasonable doubt,
That they have.
there is a veracity, Lordship.
You
Possession.
see, they have proved the foundation facts to give rise to the presumption that they have. Now it is for you to show that you were not in the bus or you were not the possessor of those cannabis or the packet that has been recovered. Where are those?
20 kg 800 grams.
Maybe
Yeah,
that
listen.
the 4
4
kg is
kg.
only taken.
Because I was the investigating officer.
So,
Lordship
you
given
see,
some
those are exaggeration. Ultimately, 4 kg is what is the trial court has taken to be proved, and they have accordingly modified. They have accordingly convicted in the offense under 20B2B,
Yeah.
not C. So that has been done. This court doesn't find anything perversity. It is not a case of no evidence. Evidence is there. And this court has no reasons to discredit the testimony of PW1, PW2, PW5, PW7.
Identity of the accused has not been established.
Driver has said
In prospect, Lordship,
that he
like
does
regarding
not
bag?
say anything else.
no, bag, regarding bag,
No.
then
That
PW5,
it's not creating any doubt in the
that
mind
PW
of this court.
who is the boy on that day and
Teaser list also you have signed.
And
Your
Lordship,
signature is not challenged.
there is no suggestion also that
That's
he was
what.
the-
There is nothing.
nothing.
Evidence is there. Here and there, some discrepancy can be there. You cannot be now acquitted because of those discrepancies. Unless and of course, those discrepancies are fatal. It has material, it affects the root. Those are some here and there irregularities. Prosecution ought to have done it with more rigor and care. The prosecution agencies needs to buckle up. All right, at 2 now it's already break. So no point of starting the judgment. At 2 I will pronounce it. I'll dictate it in the court. You all be here. Arguments completed. Judgment deal about.
May it please the law.
Yes.
My lord, may I mention item 11, my lord. There is your
Hmm?
lawsuit. It may.
You want another
item
day?
11,
You want on another date?
another day, my lord.
Okay. $11.
11.
Okay. As prayed for by Mr. M.H. Rajbar Bhuiya,
Yes.
Learned Counsel appearing for the petitioner, which is jointly prayed by Mr. So-and-so, Learned Counsel appearing for the petitioner, and Mr. A.I. Uddin, right? Learned Counsel appearing for the respondent numbers 1 to 5, relist on such and such date. To judgment day. Heard Mr. R. Dev, Learned Counsel appearing for the appellant. Also heard M.S.A. Begum, Learned APP for the state respondent. This criminal appeal is directed against the judgment and order of conviction and sentence dated 29/3/2014, passed by the Learned Session Judge in connection with the special NDPS case number 01/2011, Bokakhat PS GDE number 234, dated 11/5/2010, whereby the appellant was convicted under section 20 small b Roman 2 capital C no. Capital B of NDPS Act so and so, and sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 20,000 in default to suffer further rigorous imprisonment of another 1 year. Stop. পইণ্টত আপোনাক হেৰি দিছিলোঁ নহয় বোকাখাত PSGD সেইখিনি নিদিলেও হয় সেইখিনি এই ইয়াৰ কাৰণে কনফিউজন হৈ গ'ল The prosecution case in brief is that on 19/7/2010, the officer in charge of Bokakhat police station, PW1, na?
No,
He's
7.
7.
7.
Stroke PW7 lodged an FIR alleging inter alia that on 11/5/2010, upon receiving information from secret source, a search was conducted in a 709 bus bearing registration number AS05 capital A stroke 6774, and after conducting search, 20 kg, 800 grams of suspected ganja in 2 packets was recovered from the possession of the accused appellant. Accordingly, a case was registered under section 22 of NDPS. Upon charge sheet being submitted, trial commenced. No, trial commenced or charges, the trial court framed charges under section. Where is the charge framing? Trial commenced liquidum. During trial, as 27 witnesses were examined, including one official from Forensic Science Laboratory and PW7. Stop. After completion of trial, all the incriminating circumstances were put to the accused appellant during 313 examination, wherein he generally denied the allegations. However, he did not examine any defense in his support. Upon completion of trial, the trial court convicted the accused appellant under section 20B2B of so-and-so Act. Situated thus, the present appeal has been filed. Mr. So-and-so submits that the prosecution failed to establish that the bag containing the contraband belongs to the accused appellant, and therefore the element of possession is not proved. He further submits that the trial court committed grave error in law as well as on facts in not considering the fact that the weight of the contraband articles is contrary. He further submits that the trial court has wrongly convicted the accused appellant under section 20B2B without appreciating the evidence on record, both oral and documentary, in its proper perspective. He further submits that PW2, while deposing his evidence, appeared to have departed from his initial statement recorded by police under section 161 CRPC. He further submits that PW2 admitted in cross-examination that he put his signature on the seizure list at police station, which cast a heavy doubt on the whole procedure of search and seizure of the contraband articles. He further submits that the trial court ignored the evidence of ignored the cross examination of the PW2, wherein he clarified that he did not see what type of luggage the accused appellant was carrying at the time of boarding the bus. He further submits that the trial court failed to notice the contradictory deposition of PW1 and PW7 with respect to the weight of the alleged seized contraband articles. He accordingly submits that the impugned conviction and sentence warrants interference from this court. Per contra, Miss A. Begum, learned APP for the state, submits that the evidence brought on record clearly establishes the guilt of the accused appellant beyond reasonable doubt. She further submits that in an offence of such nature under the NDPS Act so and so, the prosecution has to prove the circumstances, has to prove those circumstances beyond reasonable doubt so as to give rise to a presumption under section 35 of the so and so act against the accused petitioner. Stop. She further submits that since the accused petitioner has not rebutted the presumption, in law having been arised against him in view of the circumstances proved by the prosecution, comma, the conviction and sentence impugned warrants no interference from this court. Stop. Yes, sir. I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the contending parties and have perused the material available on record. The issue for determination in this appeal is whether the prosecution has proved beyond reasonable doubt that the appellant accused was in conscious possession of the contraband seized articles from his bag, from the bag produced by him, comma, thereby attracting Section 20(b)(2)(b) of the NDPS Act. A careful scrutiny of the testimonies of PW1, PW2, PW3, and PW5 reveals a consistent and cogent narrative establishing the following facts. They are the main, na? 1, 2, 3, and 5. And then the 7 is the IO. And they are the eyewitnesses otherwise, isn't it? Who are the eyewitnesses? Huh? 1. The appellant was traveling in the passenger bus bearing number AS05 capital A0774, flying from Dimapur towards Tejpur. Just see the facts, huh? If there is any. Next, number 2, and get points on DDO. At Methoni near Bokakhat, the bus was stopped by the police on the basis of secret information. Methoni. The bus, at Methoni near Bokakhat. The bus was stopped by the police on the basis of secret information. The police checked the bus and the appellant himself produced the bag in question before the police. The said bag, when opened, was found to contain packets of cannabis, suspected cannabis, within bracket ganja. These witnesses have categorically identified the appellant who was present in the bus at the relevant time. The appellant has signed the seizure list within bracket Exhibit 3 in presence of the seizure witnesses. PW1, who is the weighman and and has a shopkeeper, and has a shop near the bus stand, near or where the
station.
Huh?
Near police station.
near the police station, identified, deposed that he was called to the police station to weigh the packets and that the packets seized from the accused appellant weighed around 2 kg each. His testimony corroborates the quantity and nature of the seized substance. PW2, who is the bus driver of the bus in question, identified the accused appellant as the person who boarded the bus with a black-colored bag and narrates that the accused handed over the bag to the police during search. His cross-examination clearly shows no challenge to the fact that the accused appellant was traveling in the bus. PW3, who is the conductor, helper,
Owner's son.
who is the PW3, who is the son of the owner of the bus in question, he stated that upon search, the appellant was brought down along with the bag.
He came to know. He came to know. And after seizure, his signature was taken. He is not very much relevant.
Not relevant, right?
Yes. 2, 5, and 6.
Huh?
2, 5, and 6.
6 or 7?
7 is IO.
6 is also relevant.
Yes,
Six
yes,
is also
Lordship.
relevant.
তেতিয়াহ'লে 5 টো নক'ব হা এতিয়া কোনটো কৈ আছে 3 টো নালাগে I've said 1 and 2 now the 5 PW5 who is the bus operator's representative
No. Independent passenger.
Who is an independent passenger of the bus in question stated that deposed that upon search the appellant was brought down along with the bag. That's what he said, isn't it?
Yes, yes.
He confirms the presence of the appellant and the recovery of the cannabis. PW5. No, PW3 to tar agot di dibo tetya. PW3, who is the son of the owner of the bus in question, deposed that when he was called to the police station, he saw the bag and packets kept on the table. He identified his signature on the seizure list. Six, 2. PW6, who is he?
He is also passenger.
Who is another passenger of the bus in question. His is not that evident. He simply says we were all brought down and the police found cannabis. Deposed that after police stopped the bus near a tea garden, they checked the bus after unboarding them and found cannabis inside the bus.
From whom, Lordship?
That's all right.
It's
It's not said. How can I question that now? I'm narrating what you have said. Not relevant. Other have said, Mr. Dave, no?
Yes, yes.
PW7, who is the investigating officer, clearly stated in his deposition before the trial court that he received secret information to the effect that a person was traveling on the 709 bus and was transporting cannabis. He further deposed that upon checking the bus, on checking the bus, the accused appellant was found with the bag containing the contraband. He further deposed that 2 packets of cannabis weighing approximately 4 kilograms were recovered.
No, 20 kg. 20 kg.
20
kg 800
kg 800
gram.
were recovered. He further deposed that the contraband was seized, marked and sent to FSL. He further deposed that FSL report confirmed the substance as cannabis and that he prepared all seizure documents and submitted the charge sheet. His evidence appears to be firm, consistent and unshaken in cross-examination. It appears that not a single prosecution witness was cross-examined on the vital defense taken in section 313 CRPC by the accused appellant, namely that the accused appellant did not board the bus at all. In fact, the prosecution witnesses specifically stated that the accused appellant boarded the bus, comma, was present inside the bus, comma, produced the bag voluntarily, comma, and signed the seizure list. However, the defense did not put any suggestion disputing these facts. It is well settled that when incriminating evidence is not challenged in cross-examination, such evidence remains unrebutted and can be safely relied upon. Section 35 of the NDPS Act so and so reads as under, quote unquote. Reading of the aforesaid provision of law, it is apparent that once possession of the contraband is established, the court shall presume that the accused had the requisite culpable mental state, unless the contrary is proved by the accused. In the present case, in the present case, possession of the contraband articles by the accused appellant is proved by the consistent evidence of PW1, PW2, PW3, PW5, and PW7. Likewise, the recovery from the bag produced by the appellant, comma, signature of the appellant on the seizure list, comma, identification by all material witnesses is also proved, is also established by the prosecution. The accused appellant failed to rebut the presumption either through defense evidence or suggestions in cross-examination. Therefore, Section 35 squarely applies, and possession must be treated as conscious possession. What transpires from the above is that the appellant was indeed the accused appellant was indeed traveling in the bus at the relevant time. He was carrying the bag from which the contraband was recovered. He voluntarily produced the bag to the police during the search. He signed the seizure list, acknowledging the seizure. The FSL report confirms that the substance is ganja. The defense plea is totally unsupported by cross-examination or evidence. The presumption under Section 35 NDPS Act stands unrebutted. The prosecution has thus successfully established the possession of 4 kg of ganja by the accused appellant beyond reasonable doubt. In view of the above findings, this court is of the unhesitant view that the conviction recorded by the learned trial court under Section 20B(2)(b of the NDPS Act is legal and proper. The sentence of rigorous imprisonment for 5 years and fine of rupees 20,000 is in conformity with law and does not warrant any interference from this court. Stop. The appeal accordingly stands dismissed. Conviction and sentence are hereby affirmed. Trial court record, return trial court records. Sorry. No.
He was in previous bail, Lordship, so the bail bond may be cancelled.
Bail bonds shall stand cancelled. Huh? Anything else? Huh?
According the one day earlier one in the morning, the Lordship have given this letter.
There, the bail bond has to be cancelled.
Cancel on one
It
day.
pronabe parisle na? Not credible. Okay. Yesterday's one also any?
No, it is over.
Dekhak ebar sudi lobo de hi duta kalir asil etat acquittal asil kintu etat confirmation asil ebar sai lobo ko. No, there was one of the other day that fishing hook.
They'll have to surrender.
Anyway, but you point out, because procedurally I'm not so acquainted. So sometimes these small things, but it makes a lot of difference.
Yes.
So please point out,
Cancel and surrender.
Thank you.
Number 4.
Yes, Mr. Bhatti.
My lord, for quashing of the criminal.
Washing.
My lord, this is section 379, 406, 420,
এইবোৰ কিয় লৈ গৈছ? এইবোৰ লৈ নাযাবি। Yes.
The case was registered under section 379, 406, 420, 506, 120B, 34 IPC against me, my lord. In this particular case, my lord, so far, the complainant is concerned, he is the husband of the accused number one, petitioner number one. And the complaint your lordship will find at page 45, whether it discloses a cognizable offense to be tried by the London Trial Court, my lord. Page 45, my lord.
Offense is under?
Page
Offense?
offense under section 379, 406, 420, 506, 120B, 506, 120B, and section 34, common intention, my lord. My lord, so far at page, my lord, you also will find at page 45. Complaint.
Sentence?
Not
Oh, this is
quashing.
complaint.
Quashing.
Quashing, sorry, complaint.
My lord, the complaint is
1 second.
page 45.
The respondent is there.
Yes,
You're for the respondent. Mr. Kaman, you are there for the respondent?
Yes. Only 2 minutes. It is the first response. I'm sorry, I could not.
No problem. We've just started.
Yes.
Yes. Which page
at
complaint?
page 45.
Page
45.
45.
That is,
FIR.
it is filed in the court of Justice Judicial Magistrate.
Huh?
It was filed in the court of the London Judicial Magistrate.
TJM.
CJM.
Yes,
Kamrup
please.
Guwahati. May I read it now?
Yes.
So far the complainant is concerned, my lord, he is the husband of the accused number 3, Monica Gupta.
Yes.
He is the husband of Monica Gupta. So far, the accused number 1 is concerned. He is the brother of the Monica Gupta,
Accused is who?
Mohit Gupta.
Mohit Gupta is the accused. He is the brother.
Brother of
I have heard this case earlier.
no.
I think, I don't know, my handwriting is appearing here, brother, mother and wife. Correct. I think,
I forgot it.
I may have to,
My lord,
I
it
may
is not
have,
in
because
my,
I see my
No.
handwriting here.
it is not in my memory whether this case was taken up.
Maybe you were not there. Brother, mother, and wife.
And
Yes.
so far number 2 is concerned, She is the mother.
Yeah,
Of the
taken note.
accused
And
number
number
one
3 is the
and-
wife.
See,
Number 3 is the wife.
she is the wife.
Yes.
Now, my lord, I am taking to your lordship. There are two at page 46. That the complainant is filing this instant complaint to forward the same to the Sahaga police station under appropriate section of law with a direction to arrest the aforesaid accused persons and further direction of the recovery of the amount is specifically mentioned in the succeeding paragraph of this petition. Gold, jewelry, etc., which was due to result of conspiracy faced by the accused persons. That a decade ago, the complainant and affairs with the accused number 3, when the complainant was pursuing his studies at Haryana, that even during the starting of love affairs between the complainant and the accused number 3, the accused number 3 discreetly used to take undue privilege from the complainant. He even without a reasonable cause used to take money from the complainant on a promise that she will return the same amount, but never.
In
could.
short, the husband is now filing this complaint for recovery of the money of the jewelry given to the wife.
Not jewelry to the wife, my lord. What is their claim that from the Almirah she took away the jewelry?
Stolen her own jewelries.
Not her own jewelry, but the mother's jewelry. That is
mother-in-law.
mother-in-law. And that's why, my lord, I have to read the entire complaint.
But if that is the allegation, how can this be quashed?
No.
Because she.
I would show on the
No,
face
Mr.
of-
Bhatti,
yes.
you have to understand that this case is now for quashing of a FIR. Now, this court has to be cautious that it can be and examine the averments made in the FIR on the face value and see whether any offense is made out or not.
Yes.
Suppose there is an allegation. Maybe there are 100 of allegations, but out of that one allegation is that you have stolen the jewelry of the mother-in-law.
That is my ground, my lord, in this particular case, that whatever the allegations have been made, they are absolutely absurd and inherently improbable.
Improbable. No, you see,
That
you
was the
see
point, my lord.
that
Apart from-
particular category of Bhajanlal's list has to be in the context of the case. There has to be something so improbable
Yes,
that
yes.
no
Yes,
reasonable
sir.
man
That
will
I-
believe that story.
That I am going to show your lord.
So that anyway, let us see.
Yeah. My lord, para 5.
Well, let's read the whole complaint.
all-
Yes, let us read, since I have to anyway read it. Yes. Read.
That somewhere in 2005-2006, the father of the accused number 1 and 3 got several heart attacks, which resulted him to paralysis. The accused persons during this period, showing emotional grounds, requested the complainant to make some payment towards the expenses incurred during the treatment of late Ajay Gupta. The total amount paid by the complainant towards the same is approximately 40,000. The accused persons made the complainant to pay this amount considering a loan from him and promised to repay the same as soon as possible. The complainant, being an emotional person and also understand the meaning of family ties, never questioned the accused persons, having a strong belief that he would be wife and her family members will never betray him and his expectation. He was made convinced of the prevailing circumstances by the accused persons that they will return back the entire amount which they are taking from the complainant. Nothing has been indicated what amount on which date it was taken and given. Apart from it, madam, that in the meantime, the father of the accused number 1 and 3 Ajay Gupta expired on such and such, and the complainant got married to accused number 3 on such and such, as per Hindu rites and custom. The family members of the complainant were very happy with this marriage, and they fully heartedly welcomed the new bride at her matrimonial home situated at Kukarmara, Kamrup, Assam. She was gifted with loads of gold jewelry, costly traditional clothes of Assam and other articles. that the complainant again on the request of the accused number 3 granted accused number 1 a loan amount of rupees 1,50,000 approximately in different monthly installments in the form of cash and directly transferring into his account, which he never returned. It is also the vague one. There's no detail. In the meantime, the Prakolita brother of the complainant got married on 5/3/2010. The accused number 1 and accused number 3 also attended the marriage ceremony in Kukarmara, Assam. The accused number 1 again requested the complainant in front of accused number 3 in his hometown, Kukarmara, to pay him a loan of rupees 45,000 as he was planning to shift himself in a good accommodation in Noida, Uttar Pradesh. The accused number 1 stated that he got a job in Oriental Insurance Valley and looking at his personal position, he finds it awkward to stay in low-lying area of Noida as he was staying earlier. The accused number 3 again convinced the complainant to pay accused number 1 the loan as required with the promise that he would return all the money soon as he would be a job now. That during the marriage, this is important now. Others are the statements, vague statements. This statement is very particular. That during the marriage, the accused number 3 asked for an iron safe at the home of the complainant where she could put her jewelry and deliver. And subsequently, iron safe, which generally does not get opened, was handed over to accused number 3 by the mother of the complainant with complete faith on her daughter-in-law. The iron safe also used to wear the gold jewelry of the family. That when the accused number 1 and 3 left Kukarmara home again, the key of the iron safe was handed out by them to the mother of complainant, the family having a deep faith on their daughter-in-law. The accused number 1 never preferred to open and cross-check the iron safe. That in the meantime, the family of the complainant started to arrange the marriage of their younger sisters, Gira Kolita and Ford. They were planning to remove few jewelry out of their essential jewelry stored in the same iron safe handed over to the accused number 1 earlier. On 3/1/2023, when with great excitement they decided to open the same iron safe, they got the great shock of their life that not even a single piece of their essential jewelry are placed in the iron safe, and the same are actually stolen by the accused number 1 and 3. That is the crux of the matter, my lord. In this particular case, again, I am taking your lordship back to para number 10. When it was handed over, my lord, the marriage was solemnized on 5/3/2010. And it was opened on, gave the key on 5/3/2010, opened on 3/1/2013. That is after expiry of more or less 3 years now. And nothing has been indicated what kind of jewelry-
Marriage is when? Marriage was
on 5/3/2010.
5/3,
2010.
5/3/2010.
Then when she came to Kukurmara to attend the marriage,
And it was opened on 3/1.
3/1/2013. These two are the crucial dates, my lord, so far this case is concerned.
No, this 5/5/5/3/10 is whose marriage?
That is the marriage of the complainant.
Their marriage.
Yes.
At the time of marriage, the iron safe was given, containing this is the allegation, containing the jewelries of the entire family.
Yes.
And after she left to Kukurmara, it says that for a long time they did not bother to open, but later, because of their younger sister's marriage time, they had opened on
Opened only on in
3/1/13.
13 now. More or less 3 years.
More or less
3 years now.
3 years.
3 years. That is the crux of matter. Nothing has been indicated in what kind of ancestral jewelry was kept and in whose presence it was kept, my lord. That is, now, my lord, your lordship will see, so far this case is.
Any other case also there
No,
amongst the parties?
Delhi, Delhi. There are some cases in Delhi.
Huh?
There are so many cases.
What are those cases?
About,
Maintenance, they are paying everything.
You are for
Husband.
husband. You are for
Husband.
all husband. How many husband?
One husband.
Family, husband and husband's family.
That. And the matter is on almost at the Bhat Guilty closer, because report is supposed to get in corner. Then there is a 498A, that also I maintenance I'm paying.
Is there any criminal case? Is there a criminal case made out, Mr. Biswas? Look, looks like it's a. No, Mr. Bhatti has to complete, but it indicates that
Nothing completely will produce. There are materials.
no materials of what nature? I mean, your allegations are these.
absurd, my lord, and only those have been made. This case has been.
It's
filed
all right. Mr. Bhatti will take time. Yes.
to rake the Byzance against me, my on these 2 points, and for this particular purpose, my lord, so far the accused number 2 is concerned, mother. There is no allegation so far the complaint is concerned. So she is entitled to be
Only allegation is against whom then?
only 1 and 3.
Huh?
Only 1 and 3.
1 and
3,
wife and brother.
brother, not against the mother. No allegation at all.
Yes.
And at this statement, now, my lord, I am taking to your lordship to certain documents, my lord.
At any point of time, you all will have put under some mediation or anything.
Mediation in Guwahati,
The High Court.
yes, sir, but it did not materialize.
It was done.
It is not.
It did not materialize because I did not.
She didn't come. Where does she stay?
Delhi. Maybe Ketia.
She could have attended through video conferencing. Are you willing to sit? Why are you not sitting?
All right, my through video conferencing.
You sit through. Come on, why not to send
I
this
may-
matter to the
I
Guwahati
may
High Court
pursue-
Mediation Center?
I may pursue my client.
I have no issue, man.
No, we can try.
Definitely, man.
After that, we'll come back here only.
I'll
Well,
they are
uh,
husband and wife, my lord.
Correct.
I
Correct.
appreciate your lordship.
I mean,
No, my lord, there should be an endeavor.
and it appears that a lot of other cases are also there.
No, they have been acquitted recently by the criminal court, my lord. They filed a appeal against acquittal. That was also dismissed.
Who name it?
The wife
The wife.
against the husband and the other family member.
Acquitted in
Okay,
which
okay.
one?
498A, man.
Oh,
Cardinal court.
Huh? Cruelty.
Yeah, cruelty.
That was filed by whom?
Wife, my lord.
Wife was filed against the husband,
Wife has filed a cruelty case 498.
and the husband is acquitted.
Husband is.
So husband is you.
Yeah, I'm for the husband. Right now, I'm for the husband and the family matter in this case, madam. So that's a good endeavor, your lordship is
I
appreciated.
think
Yes, sir. Through
because
the video conferencing, I am ready.
she can
Because it
attend
is
through
not
video
possible on
conference.
my part
Both
to
the parties, if
come
we
to the
should.
Guwahati and.
You people can be here. Your junior can be
Sure, madam.
here in the
No,
Guwahati
we'll
High
call
Court.
the client, our client.
Yes,
is
yes, let him be
basically
here.
From the native place.
If she doesn't
So-
want to come, it is in her interest.
So, or through video conferencing.
Yes.
that's my other friend.
You
let there
personally
be an
are inclined to come
Yes, sir.
because it's a
Face to
Because
face.
it is not, may not be possible for her to come from Delhi. to
Her age.
Guwahati. But through video conferencing, she is ready to do it.
whatever. You see, there has to be serious endeavor.
Absolutely.
Otherwise,
Yes.
it is an empty formality. I don't want to send this
I would,
matter
sincerely,
for an
I-
empty formality.
Sincerely, I would.
Correct. But just reading the first few paragraphs of the complaint, the indication is that perhaps it is some family dispute. But the hands of this court are also such that some allegation appears that there could
Yes.
be a criminal angle. In that
Yes.
situation, it is too early for this court to just, yes, it may
Yes.
not be proper.
No, that is right, Your Lordship. But so far the complaint and other
No,
documents
those are, I am yet to hear. I am saying the
Prima
prima
facie.
facie.
Yeah.
Both of you are right when you say your own cases. But I have to draw a balance somewhere. And then it would be the perception of the court what matters.
Yes, right. Whoever may win law, that's a different aspect, madam, but the legal proposition
I
should be
think
correct.
Considering it is a family issue, and why the mother?
Sure.
Why the mother? Mother is no
but
allegation.
Will be settled if they sit together and cracks the ice, my lord.
I think so. Okay. Heard Mr. O.P. Bhatti. Oh, sorry. Talk.
Oh.
Everything goes so.
Oh, yeah.
After dictating too long judgment.
Lordship minds always works 24/7. Yes. My senior used to tell my lord on the lighter note.
No, but that is for all.
Yes. All,
With the lawyers,
Yes,
rather.
that's true, my lord.
I think it is true the other side.
Absolutely.
Because
what
your minds never sleep.
Yes.
You're always
Your lordship.
consumed by the cases you are having.
Sometimes bathroom is a nice place to
Yes.
take a cool decision, my lord.
About your arguments.
Yes, my lord. Anything, my
The
lord.
placing
In
of
de-
the arguments.
My lord, in decisions of life also. Because that's a very cooler place. No disturbance, no interference. Coming back to my senior's quote, my lord, he used to say that when he used to sleep, my lord, if he gets up by saying something in his mind, murmuring, immediately he used to keep a
Write
diary, my
down.
lord. So he just used to jot down, not down at least, but jot down. In the morning, he develops the point. And that's the
So
free
you
mind
see,
solve.
most of us follow that. Nowadays, the
Dragon.
no, not dragon, but
Hmm.
even in your WhatsApp messages
Yes.
also you have these speech text. So it's becoming more easier
More easier.
to just record whatever thoughts are in your mind, and say for instance in our case we just send it to our stenos.
When I say something to my junior, I always say, right, we will put the Shakespeare language later on, but at least jot it down.
Heard Mr. O.P. Bhatti, learned counsel appearing for the petitioner. Also heard Mr. J. Kaman, learned senior counsel assisted by Mr.
P. Dev Chaudhary.
P.
Dev Chaudhary.
Dev
Chaudhary.
Chaudhary. P. Dev Chaudhary, learned counsel for the so-and-so, তেওঁৰ আগত S.C. Biswasu কৰি দিয়ক. Assisted by S.C. Biswas and so. Also heard Mr. M.P. Goswami, learned APP for the state respondent. The issue involved in the criminal petition is quashing of the GR case number 251 of 2013 arising out of Chagaon PS case number 09 of 2013 registered under section 379, 406, 420, 506, 120B, read with section 34 of the IPC, lodged by the lodged by the law. It was lodged by whom?
The husband of
Lodged by the husband of the petitioner, petitioner number 3. Petitioner number 3, I think.
no man. Here it is petition number.
Petitioner number 3.
No, one man.
Petitioner number 1. And against her brother, petitioner number.
Petitioner 3, Mohit Gupta.
Petitioner number 3 and her mother, petitioner number 2. তুমি 2 টো আগত কৰি দিবা 3 টো আগত mother টো আগত কৰি দিবা brother টো পিছত কৰি দিবা লেখোতে upon hearing briefly, it appears this matter can be referred to the High Court Mediation Center to make an endeavor to amicably settle the issue involved in the case. Accordingly, the matter is referred to the Guwahati Mediation Center fix a date, huh? So and so date, and parties are permitted to appear through video conferencing mode along with their respective counsels as far as practicable. Whatever decision they take, I'm not emphasizing that right now, isn't it? So with the councils I have mentioned.
Add one sentence probably, my lord. Upon hearing the parties, it has.
I've said-
Surfaced.
I have said that.
I've missed it.
I've said
That it has transpired that it's a family. matter.
I've not used the family, but I
But-
said an endeavor. I've said that I'll
sure.
edit it.
Sure.
I have said it in the
My-
beginning.
I missed it.
তাৰপিছত কি লিখে এইটো কোৱা যে date এটা দি দিয়ক হা date for appearance and after so and so to submit a report exercise within so and so hey date কেইটা দি দিওঁ you appear on 11 December
My lord, my lord. Much obliged, much obliged.
Okay.
Item 5.
Well, we take leave, my lord.
Mr. Mishra, this is that matter where you both are amicus, and one is amicus and one is the
Original.
engaged counsel. Yes.
This is a case, my lord, where two sister-in-laws had some quarrels between them, and one of them allegedly gave a blow on the head, and on the subsequent day, one sister-in-law died.
So fight between two sister-in-laws.
Regarding a jackfruit tree. Leaves of jackfruit tree, not jackfruit tree, leaves of jackfruit tree, and that was arose between the son and the daughter.
What was the controversy as whose the jackfruit tree belongs to?
The three brothers were there. In between their houses, the jackfruit tree was there. One claim it is my part, on my part, one claim other.
You know, Mr. Mishra, nothing to do with this case. In general, I'm saying, as you all know, that initially I was stationed at Aizawl bench. And during my stay there, I used to go for my morning walks. There are no compounds in Aizawl. There is no walls or fencing gates. There are trees, there are fruit trees, there are vegetable trees. They all share and have. There is nothing called this is my tree or this is your tree. The community spirit, the Mizo people that I've seen there is commendable. In fact, you know, in the parking which is overseeing the hills, benches are kept. You can go and sit. Nobody will come and tell you why you're sitting here. This is how it is. And look at here. Fight between two sister-in-law over a jackfruit tree, and one lost her life. And one lost her life in that fight. Anyway, on a lighter note, I shared my experience. You know? Yes.
Well, the incident took place on 29/5/2005. 29/5/2005, incident took place. The husband, on receiving the information, he came back from the work site. He took her injured wife to police station. Police sent them to hospital, got all bandages and all things, then took the wife to home. On the subsequent day, the wife died in the evening. Then
2 days, huh? That
2
means.
days. Then the police were informed. Police came and the FIR was noted down as stated by the complainant. But what the police did on the first day when the injured was taken to the police station. That is, nowhere they have stated what they have done. Means the prosecution did not say anything about that. Anyway. Then, my lord, in the eyewitness was stated to be the mother-in-law or mother, means the complainant's mother. She said, I have heard the utterings. I came to stop them, but they did not stop. Subsequently, by taking a bamboo piece, one sister-in-law gave a blow, the other died. The complainant's wife died. Not died, got injured. Then she was taken to hospital. Here the crucial point is this: when hospital, the injured was taken to hospital, there was no doctor found. That was a statement by the eyewitness, not by the complainant. The sister available in the hospital, she did the stitches and all, then asked her to come back on the next day when doctor will be there.
But she died in the night.
No. On the next day morning, as stated by the eyewitness, she was taken back again to the hospital. Doctor did his work and she was sent back. Now in the evening, at around 2:30 p.m. At 2:30 p.m., the lady died. The sister-in-law died. Altogether, 7 witnesses were there, including the medical officer as well as the IO. The police said, IO said, I had seized the bamboo. But the other witnesses said, we have not seen about the seizure. And that was not exhibited, not sent for any FSL, nothing sort. Because injury was on head, and thereafter, out of that injury, she died.
So this was your conviction is under?
Under 304,
Part 1.
7 years and 500 rupees.
304 part 1.
Yes.
Part 2.
Two.
Part 2. 7 years. Sentence 7 years.
and 500 rupees fine. May I please the translated person as I have done. Evidence. Lordship, my friend has made out a briefing argument also.
Yes, yes. An idiot. But let us first go through the PWs. You've prepared this, Mr. Mishra?
Yes,
Grateful.
the PW1 is the complainant, he is the husband.
Yeah, what did you like? Yes.
He is the husband. May I read?
Yes, please.
I am the complainant in this case. I know the accused Manzila Khatun and Nazrul Islam. This Manzila Khatun and Nazrul Islam are a brother and brother-in-law. Nazrul Islam is my own
No,
brother.
Sorry, I know the accused and Manjula. Manjula is the sister-in-law or brother-in-law?
Sister-in-law.
Sister-in-law. Yes.
They have stated, madam.
Yes.
I know.
And Najrul is the brother-in-law.
No, Nazrul is my brother.
Own brother.
Second line.
Oh, acha.
Nazrul is my own brother. Manzila is my sister-in-law.
Okay. And Najrul's wife must be the other dead. No.
No.
Sorry,
the
you
complainant's-
read.
Complainant's wife. About 1 year back from today at about 9:30 a.m., the accused Manzila had beaten my wife Ayesha Khatun. That is, Ayesha Khatun has died. I was working as helper to a carpenter at a distance of about half a kilometer at the time of the accident took place. Then my elder daughter, Momtaz, had rushed to me and informed that the accused Manzila had given a blow at the head of my wife, Ayesha, with a piece of bamboo.
Eyewitness is there.
Eyewitness is there, the next one.
That is Manjila. No,
No.
Momtaz.
Momtaz.
She is PW.
2.
Yes,
No,
please.
Momtaz is the daughter.
Not
She-
the eyewitness.
No, eyewitness. Mother, no.
Okay.
Eyewitness is Nurjahan. That is the mother
Oh.
of the complainant.
Okay. Yes, please read.
Then I came to my home and found my wife in the home at injured condition. I saw injury on the head of my wife. It was bleeding from head. On my query, my wife told me that Manzila had a tussle with her and injured her on the head with a bamboo with a blow by a bamboo. The incident took place at the boundary of my and Nazrul's house. I then came to Khatwal police station and had informed about the incident. I took the injured to the Samaguri hospital. After being treated by doctor, I brought my wife to home. On next day at about 2:30 p.m., my wife died. Up to this point, my lord, he never said that nurse treated him, and he had already informed the police. This up to this point, it is there. The police came on information given by the villagers and took the dead body to the police station. Police had seized the piece of bamboo when came for investigation. At my dictation, Azahar was written. That means the next day, Azahar was written. Exhibit 1 is the Azahar, and Exhibit 1.1 is my signature. Exhibit 2 is the Salan. Exhibit 2.1 is my signature. Exhibit 3 is the inquest report. Police had interrogated me. In the cross, the house of me and my brother Nazrul is nearby. My house is at the north side of the road. The house of my brother Moinuddin, another brother is there, is on the west side of my house. Moinuddin have his family. My brother Nazrul has got 2 sons. The house of Moinuddin is at a distance of about 200 knols. That is generally it is called maybe far longer maybe. From the house of Nazrul. On the south side of my house, there is the PWD road. This road goes from east to west side. This road goes to Rupohi on west side. In the east side, it goes to Sibastan via Barama. Through this road, people continues to move day and night. On the southern side of this, there are houses of Malu and his son. These people are residing with their family. There is a courtyard in between the road and the house. The incident took place on 3/35/2005, my lord. Now he said incident took place on 3/5/2005. Though he earlier said incident took place on 29th. The incident occurred at 9:30 a.m. On the day of the incident, I was working at the distance of about half a furlong away. I had not seen the incident of scuffle. Police had interrogated me. It is not a fact that my daughter Momtaz had told to the police that Nazrul Islam had broken the head of my brother, her mother, by beating her. After coming to home, I found my wife inside the house at injured stage. At the time of asking my wife, the neighbors were present. They were altogether 10 persons there. It is not a fact that I had not said that Manzila had given a blow from behind with a bamboo stick. The jackfruit tree falls in our park. The jackfruit tree is at the boundary, and in this regard, sometimes quarrel takes place. I did not see the incident of scuffle. There were concrete slabs lying in between the houses of us and houses of Manzila. I cannot say if my wife fell down on the slab and got injured. This line may be noted down, my lord, because in 313, my lord, the accused Manzila stated that due to scuffle, she fell down and she got injured on her head.
Who got hurt in the head?
Aisa, the
Aisha.
died lady.
This is the 313 statement.
She stated in-
And that is why the cross, the foundation is laid.
Yeah.
Yes.
At first, I took my wife to Katwal police station and informed about the incident at the police station. I had informed the police on the date of incident. From there, the police had sent us to the Samaguri hospital. Now, police has sent to the Samaguri hospital. My wife was not admitted in hospital. She was sent back after doing bandage. On the next day, my wife died. After the death of my wife, I had lost the written as a her. It is not a fact that I had informed about the incident on the date of its occurrence. It is not a fact that I had lost a false case. My mother stays with Mainul. The age of my wife is 60 years. My wife is 60 years. It is not a fact that I had stated before the police that my mother had placed the piece of bamboo used at the time of scuffle before the police. The piece of the bamboo is not seen in the court today. I cannot read Exhibit 3 and I do not know what is written in the same. The police came on the day of death of my wife. It is not a fact that I adduce false evidence, false statement. Now I witness
Two.
the mother, witness number 2, mother.
Only a eyewitness.
Only I to witness. My name is Manzi Nurjahan, alias Murjahan, M or N, whatever name. Aged about 75 years. The complainant Bilaluddin is my son. That Bilal or Bilaluddin is the same.
It's all right. You go on.
Accused Nazrul is my son. And Manzila Khatun is my daughter-in-law. Both of them are present today. On about 2 years back, one day at about 9 a.m., it was a Sunday, my two daughter-in-laws, Aisa Khatun and Manzila Khatun, had involved in a scuffle. The issue was regarding a jackfruit tree. My 3 sons were staying in separate houses constructing on 1 plot of land. The houses are adjacent to each other. At the time of the incident took place, I was staying with my second son. His house is about at the west side. The house of Bilaluddin is on the east side of us, to us. The house at
The second son is not the wives are not of the second son, na? So she is a neutral only. She is not staying with any of these 2 sons.
The house at the middle of is of accused Nazrul. That means husband and wife. That is Nazrul. Manzila and Aisa were tussling since the day before. I tried to stop them, but they were not listening to me. On Sunday, when Aisa came back from field after leaving the goats for grazing, Manzila had given a blow on her head by the end of a piece of bamboo of about 1.5 hand long in front of the house of Aisa. Then Aisa held the injury on her head with the end of bamboo. Manzila had suffered with Aisa by holding her injury on the head. Aisa fell down in front of the door of by front side up position. That means she was lying. While Ayesha was lying, Nazrul came. The stripes of bamboo went inside the head of Ayesha and the head was broken. Blood came out. There was continuous bleeding. When the couple was going on, I had searched for Moinul once. Bilal came and took us to Samaguri hospital. Doctor was not there. The nurse did the stitch on the injury by cutting here. Had asked to go there on Monday again. On Monday, the doctor, after
It is
monitoring
already under part 2, na? Second. It's already.
already.
Well, I think it can be converted from 7 years also, it can be brought little down.
I am also thinking on that because it cannot be exonerated. She cannot be exonerated because she herself involved. She was herself involved.
Witness is very much specific, cross also.
No, no, that's why you see, I said perhaps 7 years is little excessive. Do you look, I'm only expressing my mind.
Yes, maximum punishment given.
Because it doesn't look like there is any planning and all. They both were fighting.
Yes.
During the fight,
That is why part
she picked up whatever she got, and it's a bamboo. It's not like a dagger or a dangerous weapon. And it was in that heat of the moment that this
Whatever she
happened.
found, she used it.
It looks like that.
Yeah.
So there's that Sukhbir case, I think. It was over mud being, it was brooming. And when this person was walking by, mud got splashed. So there was a fight. Then he ran to his house, got a dagger, and gave him. But that the apex court converted also. And I think it ultimately made it 5 years or something.
that part.
You look, huh? Sukhbir.
Yes.
Sukhbir. Of course, I'm yet to see.
Yes, yes.
But I mean, we don't know what way the directions will go. Maybe who knows? We can find a case of acquittal also. We don't know. But if going by the eyewitness version, if that is not challenged, not shaken, that stands uncorroborated, that fully corroborated, then it is clear that both were involved in a scuffle.
Sure. That is clear.
That much is clear.
PW2, she is the only eyewitness, but in fact, in her cross, she admitted she did not see anything.
That is
She was not at all present at that
I
time.
am going to that matter. She was with her brother
Maybe she
somewhere
slept,
else.
yes.
Oh,
She was
We have to go to
with,
verdict.
with her brother.
that comes in the cross.
Yes.
Okay.
On
Yes.
Last line. On the Monday in the evening at about 4 p.m. after running from Samuguri, Ayesha had died. Police came and took Ayesha to the police station with them on Monday. In a public place near the house of father-in-law of Bilal, she was buried. She was buried. The police had interrogated me twice, once at home on Tuesday in the daytime at Khatwal police station. At the time of incident took place, none of my sons were present at home. My age is now 80 years. The powers of the eyes have gone lost. It is difficult to identify persons. Today I have been brought
By Bilal.
Bilal has not brought me after tutoring to adduce evidence. There was a jackfruit tree at the boundary of Nazrul and Bilal. There was a tussle between Mumtaz and the daughter of Bilal and son Nazrul with regard to not collecting leaves of the jackfruit tree. taking the same into issue, the scuffle between Manjula and Ayesha got started. At the time of scuffle between Manjula and her, I was in the house of my brother. The house of my brother is at 3 furlong distance. After returning from the house of my brother, I found that they were fighting. I tried to stop them, but they did not hear. There was no stone lying near the tubewell of Bilal. Later on stated that I do not remember whether there was stone there or not. Ayesha did not fall on the stones. She was lying outside the doorsteps. I could not find Nazrul there at the time. At first, I took up Ayesha from the place where she was lying and her injury on her head. With her, I think.
She is an eyewitness.
In the.
She came back from her brother's house and she saw them fighting.
Yeah.
And in her evidence, she has
Yes.
said that part also.
Yes.
Nothing there in the cross saying that that is not correct.
That is I first scolded them. To stop the fight.
Correct.
Yes, yes, she was,
So it.
She came back.
when it was started, she was not there, but. later on
Maybe,
she was there.
maybe, but she came back. After returning from the house of my brother, I found that they were fighting. I tried to stop them, but they did not hear. You see, cross is only what is asked.
Yes, yes, yes.
Evidence in chief is clear that I tried to stop them.
Yes, that is the.
And here also it is very clear, Manjula and Aisha were tussling since the day before. I tried to stop them, but they were not listening to me. On Sunday, when Aisha came back from the field after leaving the goats for grazing, Manjula had given a blow on her head by the end of a piece of bamboo of about so and so. Then Aisha held the injury on her head. With end of the bamboo, Manjula had scuffled with Aisha by holding her injury on head. So graphically, she has narrated the incident.
That is there.
Aisha fell down in front of the door by front side up position. And in cross, she only said that at that time I was in my brother's house. I come and I see them
The
fighting.
incident was going.
So it's a continuous.
Incident was going.
There is nothing contrary.
Contrary is on the part of that who treated the patient. That is
Not material.
material that much.
Those has no material contradictions.
Yes. Now, if we skip three, now we can come to three, madam. But she is hostile, declared hostile. She is the wife of Moinuddin.
How is it relevant then?
So I am also skipping it, madam. Here, madam, just one line she said that Nazrul and Ayesha had Nazrul had killed Ayesha. That is there. But that is not material because it is hostile. Now comes.
No, but that if that part is supported by any other evidence, then
No,
it
no.
becomes, huh?
Now PW4 is the brother of Ayesha Khatun.
PW2 in her cross, she admitted that she has lost her eyesight. In her cross, the very first line.
I saw. I'll hear you, Miss Chaudhary. I saw the powers of the eyes have been lost. It is difficult to identify a person. But you see, Miss Chaudhary, her powers of eyesight may have been lost, and she may have difficulty in identifying people. But when it comes to her daughter-in-laws,
The scuffle was there.
it is not difficult for her to know that. She will know that. And it's not that she has become blind. It is difficult to identify a person. So that means it may be that the cataract is at a matured age When the cataract matured, you see, you have a blur vision. It's not that you're blind. So we don't know. She's an 80-year-old. She's not saying that I have become blind and I cannot see. That's not her statement. She clearly says the powers of the eyes have been lost. It is difficult to identify a person. So it means that she may have difficulty in identifying. But the family members, she'll be aware. I don't know. When I see, it's how things are, because if that's a doubt, then you are right. If that doubt comes and it's a reasonable doubt, then of course the benefit will go to you. Now, in that situation, we may have to discard the entire eyewitness part. So, but how it has proceeded, let us.
Yes.
I'll hear you, Ms. Chaudhary.
Uh,
I don't think we'll finish it now, so we'll have it on another date. But I'll hear you in your turn.
Yes, if we skip PW3, then we may come to PW4, my lord. That is the brother of the deceased wife, Miss Ayesha.
Yes.
PW4, Ahmad Ali.
Yes.
I have come to depose after receipt of summon. I have come to depose in connection with the death of my sister, Ayesha Khatun. I have not seen the incident on the day of one day on Sunday. About 2 years back, Bilal had taken my sister to Samaguri Hospital. On being asked, she said that a scuffle took place and Manzila had beaten her and crying as to what will happen now. I had seen the injury on the head of Ayesha.
Ahmed is his sister. Ahmed is the sister. Brother.
Brother of the deceased.
Yes.
I had seen the injury on the head of Ayesha. On Monday, I had received the news that Ayesha had died. I again went there. The police had investigated on the matter. When the police went to the house of Ayesha, I had gone there. Police had noted down. Police did not seize anything. I cannot remember that police has seized a bamboo. Now cross. It is not a fact that during the investigation I had not stated before the officer that I went to the house of Ayesha on her return from hospital. Then Ayesha had stated that Manzila had beaten her. It is not a fact that today I have made a false statement that my sister had been was beaten. Typing is there. Beaten by Manzila. On Monday at about 4:30 p.m., Ayesha had died. When I went, Ayesha was not at a stage to speak. This is not a fact. Now comes the other brother, that is Moinuddin. Moinuddin is nothing that he went to the work field and he was informed by his mother that tussle was taken place and she died. This is the deal. See, he was not a eyewitness or nothing sort, just he hearsay evidence, he has made the statement. So these are the oral evidences. Now the medical evidence is there. Medical evidence is there, my lord. That is PW 6. I have not given it because it's already typed out in the record, my lord.
Yes. Can you read?
But, on 31/5/2005, while I was attached to BP's civil hospital as SDM and HO, I did the postmortem at 5 p.m. on the dead body of Ayesha
Where is
Khatun
this music coming from?
from that side, my lord.
What is happening?
That park side.
Park.
I was also searching from where it has come, that park side.
But why a program with such loud music is allowed during the court hours? No. Vaishrav Kobo, Ajik. It is because there are no windows only in this building. I wonder from where the sound has come. That's what. That means it must be played very loud, no?
Yes.
Huh, Mr. Mishra, Mr. Goswami, Mr. Chaudhary? It must be being played very loud.
Very loud.
I did the postmortem at Lordship Court.
Yes, yes.
I did the postmortem at 5 p.m. on the dead body of Ayesha Khatun, 28 years, female, of police requisition in connection with the Khatwal police station case number 10 of 2005 under section 302 IPC on being identified by Constable Bhugeshwar Bora, 1, Mohammad Bilaluddin and Hassan Ali, and found the followings. Physical examination, that a body of average built adult female, about 28 years, eyes closed, mouth closed, rigor mortis nil, oblique stitches wound over right frontal region.
This is exactly I had in my mind, that cross-examination. He stated that if the proper treatment had been provided to the deceased at proper time, there was chance of survival of the
Yes,
deceased.
yes.
So, what is the exact injury noted?
Injury noted, my lord, in the first page, my lord.
Oblique siege
stitches wound
over right frontal region of the skull.
then B.
1 inch to 1 inch. What is that?
Now the B.
The measurement.
Yes.
How big will it be?
1 inch means just this much.
Fracture of frontal bone of scalp, my fracture of scalp.
One transverse fracture on the frontal bone.
bone. That is
Rest of the scalp are healthy.
because that resulted into my lord
Clot.
hemorrhage, shock and hemorrhage.
So I think clot.
Shock and hemorrhage due to injury and fracture.
On the first day, that sister gave her stitching. No,
Yes,
stitching was done, but
Stitching
the
was done.
doctor examined on the next day.
if we go by the eyewitness, but complainant did not say like that.
Sister not examined.
No,
Then doctor examined. So doctor have said anything about
no, the doctor.
postmortem doctor?
Postmortem doctor inquiry. But the doctor who first treated
That
the
has
pa-
not been examined. Those would have thrown some light.
Yes, my lord.
What was the condition of the wound? Now, not presenting them also maybe in adverse inference.
Because once the bandage is done, then after some time it will.
Because one thing is very clear, there cannot be any other motive. They are
Yes.
not organized criminals.
Mutual fight is heat of the moment.
Considering the nature of the injury, death not immediate after the weapon used, 7 years may be probably.
Little bit higher side. Right.
And you cannot say that the mother did not see,
Yes. At the
because
starting point, she may not be there, but later on.
in
she
the
was there.
cross, though that part has come, but is there any suggestion that you have not seen it, that you have not seen the witness?
No, my
No,
That is not there. And in 313, what is the stand?
313, my lord, everything was denied, but on the last part, my lord. The last part. I have Manjila said, my lord. on the day of incident, there was a quarrel between me and Ayesha. She caught my hair and pulled me. Then at the course of scuffle, Ayesha fell down on the pakka slab and sustained injury on head.
That can also happen.
That is also, my lord, aiding the injury, my lord.
You see, because these are the defense has to only probabilize. Now, during cross-examination, that part has been brought. There is a in the cross-examination of PW1
Yes, that was.
that was brought. So right in the beginning, the defense have taken that plea. And the mother-in-law, you don't know, she herself says that her eyesight have been lost.
Yes.
So how can she see about she may recognize their voice, but how does she know that the use of the bamboo?
Yes, but loss means to check the what exactly in the context.
No, the benefit of doubt will go to whom? Then there are two perception that she has lost her eyesight. Eyesight lost is lost. Isn't it, Miss Chaudhary? That can be also.
Check the evidence from.
Nothing has come. Prosecution ought to have brought all this properly. But eyesight loss, she says. She cannot identify people. And yet she have seen the bamboo stick.
In Assamese, my lord, it is said, মোৰ বয়স অনুমান 80 বছৰ হৈছে, চকুৰে পোহৰ বৰ্তমান নাইকিয়া হৈছে। মানুহ চিনি পাবলৈ অসুবিধা।
মানুহ চিনি পাবলৈ অসুবিধা লাঠিডাল উঠোৱাটো কেনেকে দেখা পালে? Can you read that entire that cross-examination?
Yes, my lord. Yes.
No, somewhere she said, no, that bamboo thing went inside the head.
Yes, yes.
Huh?
Yes.
But in the post-mortem, anything about
Nothing.
something going
Nothing
in?
said. Nothing.
Huh?
Nothing said.
That is not there, na?
Nothing said.
No, you please read PW1 once, that Assamese version.
Yes, ma'am. PW1. ma'am.
Yes. One is that mother, na?
No, 2.
No, mother. Read the mother's version and then the post-mortem once again. Any clue about the bamboo?
And
No.
Police, she said she did not see the incident. This is a statement before the police.
Okay,
Different.
but that is
Yes.
161.
PW2 in Assamese version.
Yes.
গুচৰীয়া বিল্লালউদ্দিন মোৰ ল'ৰা হয়। আসামী নজৰুল ইছলাম মোৰ ল'ৰা ও মঞ্জিলা খাতুন মোৰ ছোৱালী। মোৰ বোৱাৰী, not ছোৱালী, বোৱাৰী। দুয়োজন আজি উপস্থিত আছে। 2 বছৰ আগত এদিন দিনৰ 9 মান বজাত ৰবিবাৰ মোৰ বোৱাৰী দুজনী আয়েশা খাতুন আৰু মঞ্জিলা খাতুনে কাজিয়া কৰিছিল কঁঠাল গছৰ বিষয় লৈ। তেওঁলোকে বেলেগ বেলেগ ঘৰত একঠা মাটিতে ঘৰ সাজি আছিল। অৰ্থাৎ মোৰ 3জন ল'ৰা 3টা ঘৰ বনাই আছিল। ঘৰবিলাক ইটোৰ লগত সিটো লগালগি। মোৰ মাজু পুত্ৰ মইনুদ্দিনৰ লগত ঘটনাৰ সময়ত মই থাকিছিলোঁ। তাৰ ঘৰটো পশ্চিমত, আমাৰ পূব পিনে বিলালৰ ঘৰ, আসামী নজৰুলৰ ঘৰ, মাজৰটো আসামী নজৰুলৰ ঘৰ। মঞ্জুলা আৰু আয়েশা আগদিনাৰ পৰা কাজিয়া কৰি আছিল। মই মানা কৰিলে মানা নাছিল। ৰবিবাৰৰ দিনা পুৱা 9 মান বজাত আয়েশা পথাৰত ছাগলী এৰাল দিবলৈ গৈছিল। ঘৰলৈ ঘূৰি আহোঁতে আয়েশাৰ ঘৰৰ সন্মুখতে মঞ্জিলাই আয়েশাৰ মাথাত ওপৰত এটা 1.5 হতীয়া বাঁহৰ গুৰিৰে মাৰি দিয়ে।
How did she see all that?
তেতিয়া আয়েশাই নিজৰ মাথাৰ জখম ধৰিলে। মঞ্জিলাই বাঁহৰ গুৰিৰে কোবাই আয়েশাৰ মাথাৰ জখমত হাতেৰে ধৰি দৌৰা দৌৰি কৰিলে। ISI নিজৰ দুৱাৰ দলিৰ বাহিৰত চিট হৈ বাগৰি পৰিছিল ফ্ৰণ্ট সাইড আপ ISI পৰি থাকোঁতে নজৰুল আহি পালেহি ISR
Mr. Goswami, the evidence is insufficient for 304.
Yes, but the way she is describing, it cannot be a mere, because she might have lost her vision. That is a normal, my lord, regarding
Then
decreasing the
how have she seen?
decreasing the vision, but the
Where
way
have she seen decreasing the
but
vision?
decreasing the
Her
vision,
her
but-
statement is she's lost.
but the
So
way
who
she
power
is
goal?
explaining that cannot be disbelieved, my lord.
That is the more the reason that there
Yes,
is a
yes,
doubt
yeah.
coming to the mind of the court that she's
Yes.
been tutored.
That cannot be.
That she's been tutored.
That's
She may be tutored.
maybe, my lord, but
So if these perceptions are there,
yes.
if there are two views, then
But my lord, in the fighting, my lord, there is my lord element, my lord,
element of what?
that they are fighting since
Maybe they are fighting.
since the previous
Maybe
day.
they were fighting.
In the previous day.
They may be fighting.
And thereafter, on that day also she,
There is
told
no
them-
denial of the fighting.
And
Maybe she's
thereafter-
fighting and she fall down.
yes, and
Maybe
thereafter.
she got hurt. Where is the postmortem report saying that this is a bamboo injury?
It will heart injury, that is what. I have not
It's
seen
a-
exactly what.
No,
I-
see, this has to come. You see, we cannot presume all this. The medical evidence is not also supporting your bamboo injury.
It is.
Someone have said it went inside the head.
Head injury.
Yes.
No, it says something went inside. Anyway, please finish this part.
Yes.
Yes.
Mr.
ISR মাথাত বাঁহৰ বিলাক সোমাই গৈছিল
Ah. So where is it all that in the postmortem?
মাথা ভাগিছিল
Where is it in the postmortem? Bahar Akbur Humaise scratches and it poked inside her head. So there must be something to indicate in the postmortem.
And that too, the original doctors who did the treatment. he
That
was not
whoever, but in the postmortem, so this will all come.
This will come.
It should have come.
Yes.
What has come? They only stitch.
ৰক্ত বাহিৰ হৈছিল তেজ বৈ গৈছিল দবৰা দবৰি কৰোঁতে মই মঞ্জুলাক এৰুৱাবলৈ বিচাৰিছিলোঁ বিল্লাল আহি আমাক সামগ্ৰী চিকিৎসালয়লৈ লৈ গ'ল ডাক্তৰ নাপালো নাৰ্ছে আহি
I don't know. I feel it is short of.
জখম চিলাই দিলে
We'll continue, Lordship is continuing. So I will read over.
You look
the-
into it properly.
all the evidence.
You look into properly all the evidence.
Yes.
Tomorrow, day after tomorrow,
I will try to assist.
Thursday.
It requires some.
I think you have more or less finished. Miss Chaudhary
Yes.
can do her.
add something
Anything more to add? No, your part. In
My-
your part,
from my part it may be completed
first I will hear you, on Thursday, and then Mr. Goswami. So you find you point out those incriminating, like what exactly the eyewitness have because you have contradicted through cross examination. So what are those contradictions? Make a list.
I've given in my written.
Yes, I will see that, but point wise, just pinpoint those contradictions. Because if he has lost his eyesight and 161, just read the 161 till he comes. পঢ়ি দিয়ক বাইদেউ পঢ়ি দিয়ক
161 okay
read it, Mr. Mishra.
কোনটো তাৰিখে আধাৰ পৰা আৰম্ভ কৰিছো
Heard Mr. Hiri, M.K. Mishra, Amicus Curie, S.B. Chaudhary, Learned Council for Appellants, আৰু এফালে MP Goswami, Hardin Ford, আৰু fix কৰি দিবা Thursday. Yes, read.
yes PW2 statement
No, 161.
161 বাইদেউ ক'ত আছে
Achha.
161 is not now.
এইকেইটা দিছা. You find out from the trial code 161 what initially she has said. That also might have some, because we have to, you see, because he's an eyewitness. So first and foremost, whether she's trustworthy, because she's undoubtedly an interested witness. She's the mother-in-law of
Here, brothers.
correct. So she's a related witness. Now, how do we know which son she's favoring?
Yes, that
We don't know that. So you see, it's not that automatically this court will doubt her, but in the manner it has come, that she said she's lost her eyesight, then it's so much precision. She's, as you have said, she's narrated the incident. She's in fact seen how that thing going in. Hare, how did she see if her eyesight has been lost?
Please, I'm agree.
So that is making the court
Yes.
doubt her testimony.
Yes.
So then I'll have to see what was her initial stand. 161. So look into all that, huh? First day.
Without
Just
any
slip.
hesitation, she is dictating like that.
No, that's why. Some doubt is coming. Okay. Thursday.
Nylon.